Sugod na ta, James.
Mano, 1 p.m. pa ta, but we are already live on YouTube channel. So just to make you aware.
Siya, di bawal na ako mamalikas di ay.
Dili na
Stop sana. Stop sana ako kung video. Sugod na ta, James.
O niya pa 1 p.m. 15 minutes to go. Pero ikaw ang first speaker, ha? Okay. Mano, 1 p.m. pa ta.
Anong kabalik-balik? Do, tawagin si Attorney Nartea. Tignan madayon ba ang schedule karon for settlement? Tignan madayon ba ang schedule ron for settlement? Tagay ng tubig natin. 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 Tagay ng tubig natin.
Okay, so good afternoon, everyone. Good afternoon, students. Good afternoon to our invited lawyers who will be speaking with the various laws that we have in the country. And of course, I would like to greet also our viewers in our YouTube channel in Wiser Pinoy TV. Have a good afternoon, everyone. So for this juncture, before we start with our first speaker, I would like to request everyone to put ourselves in the holy presence of God for our invocation and to be followed by our national anthem via multimedia.
Let us pray. Lord Jesus, as we enter this training hall, we bring your presence with us. We speak your peace, your grace, and your perfect order into the atmosphere of the session room. We acknowledge your lordship over all that will be spoken, thought, decided, and accomplished within these walls. Lord Jesus, we thank you for the gifts you have given to each one of us. We do not take them lightly, but commit in using them responsibly and well. Give us a fresh supply of truth and beauty to which we draw our strength in doing our job. Anoint our creativity, our ideas, and our energy so that even our smallest tasks may bring you honor. Lord, when we're confused, guide us. When we're worried, energize us. Lord, when we're burnt out, infuse us with the light of your Holy Spirit. May the work that we do and the way that we do bring hope, life, and courage to all that we come into contact with. And Lord, even in these days, most stressful moments, may we rest in you. In your strong and powerful name we pray. Amen.
James, nakamute ka.
Okay, so thank you for that. Thank you for coming. I know that everyone is quite excited to finish all this event because Christmas break is coming up and our speaker is already here. So allow me to have the honor to present and introduce to you our guest speaker who will be discussing about the administrative law in the context of public service. So he is a graduate of Central Mindanao University and of course an alumnus of Bukidnon State University in his Juris Doctor degree and a lawyer, a recent passer of the Best Bar Ever and a named partner of the NBSV Law Office and Associates or Nartia Boho Santo Niño Vilon. Ladies and gentlemen, our esteemed guest speaker for this afternoon, Attorney Petros Absalon Catarata Boho. A round of applause, please.
Thank you, James. Good afternoon, guys. I am happy to be here with you. I hope klaro ba ko? Can you hear me properly? Okay, thank you. I was informed by Attorney James Violon, who is my hermano in our fraternity Tanggol, which is Fraternitas, and also a partner of our law firm, that I will be speaking to criminology students. So I'm tailoring my lecture this afternoon nga patok para sa inyo mga criminology students. Kaya most of you are planning to be police officers someday, or public servants. So, what is administrative law? Simply put, administrative law is a branch of public law which fixes the organization and determines the competences of administrative authorities. And it indicates the remedies available to individuals for violation of rights. So basically, administrative law is a very broad nga subject. Ako kayo ning kuan. It encompasses all the frameworks of government, both internal and external. So unsa may buti pasabot aning frameworks of government. Ang isa ka estado, isa ka nasod, galihok siya pinaagi sa iyahang mga instrumento. Dili man ang isa ka nasod sabat lagi ni permitting. James, unsa ni pag kuha ni permitting? Well, anyway, ang isa ka nasod, galihok siya gamit sa iyang mga instrumento. Dili manggod ni nga ang isa ka nasod na sa isa ka tawo, presidente for example, may ka nga the state is the president or the government is the president. No. Ang estado tungod sa iyahang kadako na naa siya mga instrumentalities, naa siya mga agencies, naa siya mga offices nga mo'y magpalihok sa unsa mang balaod or unsa man nga palisiya nga naaprubahan. So kaning tanan kaning laws, rules, regulations, policies is part of administrative law. So bahino nato ang administrative law in that respect. Naatay external administrative law, napod tay internal administrative law. What does it mean kung moingon kag external o internal administrative law? Internal administrative law, mo ni siya ang laws, rules, and regulations and policies nga govern sa internal mechanism of government. So, for example, nga related sa inyo sa pagka-police, promotions, that is internal, kung unsay rules para ma-promote ka, rules regarding sa unsaon pag-procure o supplies, those are internal mechanisms. Hierarchies, organizational structure sa isa ka agency. So, na kay chief of police, na kay regional police nga directors, na kay kanang mga lieutenant, sergeants, SPO1, SPO2, unsay roles sa kada usaa na, unsay ilang duties, unsay ilang functions. Those are internal mechanisms. Those are internal nga laws sa kanang covered bali sa administrative law. How about external? Ano sa may meaning ang external? Kaning sa external nga administrative law, mo ni siya nga mga butang nga ga-govern sa pinakasimple ani nga binisaya guro. Kung naa kay nalapasan balik ka sa imong katungod, unsaon nimo paggamit sa mechanism of government para ma-redress ang grievance nga imong experience. Unsaon ka nga matagaan og remedy. Isa ka example ani, for example kanang naa kay yuta. Ang kaning imong yuta kanang gusto nimong patituluhan. So kung gusto nimo patituluhan, una gusto kag survey. So kung ipa-survey nimo, ahamang kamo adto to kag DENR. Unsa may require sa DENR para makuantong imong survey? Amo to ang external nga rules nga apply sa persons, sa citizens, sa individuals nga unsaon nila paggamit sa pagpadagan sa gobyerno para sa ilang own nga katungod. Okay? So, muna basic bali sa administrative law, kung unsa ang administrative law. So ato ang i-focus dayon ni ron sa unsaon nato ni pag-apply. Unsa ning administrative law nga kanang importante para sa ako para mo apply sa ako isip ko nga tao. So lisod man ta mo discuss og internal administrative law tungod kay dili pa man mo naa sa gobyerno. Okay, pulos ta mag-discuss po ani tungod kay grabe man kay ni ka-broad. Each nga agency of government, each office of government, kanang napod sila ilahang own nga rules and laws nga ka-govern sa ilaha. So mag-focus lang ta karon sa in part sa external administrative law kay mo man ni ang makaapekto sa atuha. So una, kung ingon ka og administrative law, unsa man bali ang ako ang dapat una-unahon. Muingon ba ka kung external administrative law, muingon ba ka nga kani ba siya nga kani siya nga butang kinahanglan ba ni sa akong kinabuhi? Makaingon ba ka nga kinahanglan ba nako ni mabaw-an ang unsay basic nga rules and laws nga ga-govern sa administrative law para sa ako ang day-to-day life? Yes. Ngano nakaingon man ka? Simply put, because tanan ta governed by laws. Labi na kamo nga mo trabaho sa gobyerno. For example, mo apply ka og kanang pagka-police. Unsay requirements? Unsa ang kinahanglan nimo nga agian nga proseso? Unsa ang imuhang buhaton, for example kung kanang na-deny ang imuhang application because of a technicality na bakay remedyan na. Kung pag-apply nimo kanang gipangwartahan ka sa isa ka staff sa Napolcom, unsay imong remedy? Kung ang imong pangalan na apil na sa lista then pagkahuman gitangtang bali tungod kay naay gipalusot nga lain nga unsa na lain nga parente bali adto sa opisyalis o sa katong staff, unsa imong remedy? Those are administrative laws nga ga-govern na. Dili na siya sa korte nga para mo tubag bali ana. How about ani? Naakay kaaway. Ang imuhang kaaway kuhan ka kanang gireklamo ka. Pagreklamo sa imuha, didto ka gireklamo una sa prosecutor. Ang prosecutor na sipyat ang ilahang pagkuan, feel nimo nga di gid ka dapat nga makit-ag probable cause. Unsa imong remedy? Muhulat na lang ba kamo adto sa korte? Or naay laing remedy available sa imuha sa administrative law. So, kaning tanan nga mga butang naani sa administrative law. In fact gani ang sato ang system of court system nato ga-revolve first sa administrative law. Natay ginatawag nga exhaustion of administrative remedies nga atuas ang i-exhaust bali ang atuang remedies sa administrative nga kanang laws ay hatamo adto sa korte. So magsugod ta una sa kanang aspects unsay fundamental nga rules and laws nga ga-govern sa administrative law. Guys, ang tubig do, okay? So first, external. Muna siya ang kanang requisites para sa imuhang rights sa administrative law to procedural due process. So first is the right to hearing, which includes the right to present one's case and submit evidence in support thereof. Sa administrative law, kinahanglan gyapon ta og due process. So by due process, it means naatay right to notice and hearing. So kung naay kaso, either ikaw ang gikasuhan or ikaw ang mukaso, kinahanglan nga naay notice o hearing sa ana nga butang. So i-present nimo imong case, na kay right to present your case, and mo submit sa imuhang evidence, whether ikaw ang nikaso or ikaw ang gikasuhan. Second, the tribunal must consider the evidence presented. So para na ay due process, dili lang nga kinahanglan ka nga naay hearing, kinahanglan pod nga i-evaluate bali sa kung kinsang opisina, kinsang nga agency or tribunal ang gadungog ana, kinahanglan nila i-evaluate og tarong kung unsa imong gihatag nga ebidensya. Dili pwede ang opisyalis o ang tribunal nga gibutang lang, gisubmit lang dito, dayon di niya basahon, di niya sabton kung unsa ang ipahingon. So para nga ma-enforce na nga kana bali nga kinahanglan niya nga naibasahon niya, sabton niya ang imuhang reklamo, imong ebidensya, kinahanglan ang iyahang desisyon nga buhaton kay supported sa evidence nga gi-present nimo or gi-present sa other party. Dili pwede nga gikan lang sa iyahang imahinasyon. Dili pwede nga muingon siya nga guilty gyud ka kay tungod kanang nadunggan nako sa ako ang silingan nga gilad kag batasan. Pero wa man to gi-present nga evidence. Wala man to nga naadya parte bali sa inyong gisabutan. Di ba? So dili pwede na, kinahanglan kung katong i-consider ang unsalay na present sa ilaha. Moingon din siya nga nagdamgo ko tong niaging adlaw nga nakita nako sa akong damgo nga ikaw gyud ang sad-an or ikaw ang dautan. Dili po na pwede kay dili man na part sa evidence ang iyang damgo, di ba? So dapat ang iyang decision nga buhaton kay kanang naay support. Okay? And ang kanang nga support dapat either katong sa evidence ninyo ang gi-present sa both parties or appeal sa kanang jurisprudence nga na render sa Supreme Court or by laws and the rules itself. Okay? Fourth, the evidence must be substantial. What does it mean nga substantial ang evidence? Ipasabot lang ani nga substantial evidence. Dapat ang evidence is more than a scintilla to prove ang imuhang case. So ibuti pasabot dapat dili siya nga scintilla, Latin ning scintilla, ibuti pasabot sa scintilla kay katiting or gamay spark. Igo lang gamay nga kuan bali nga bordering on irrelevant. So dapat more than a scintilla, dapat dili siya nga gamay lang, dapat substantial. So for example, what does it mean kung substantial evidence in matters of administrative law? Naay duha ka tawo, ang isa ka tawo niingon siya nga iyahan ni nga yuta. Ang iyahang rason sa pag-ingon nga iyaha ang yuta tungod kay kanang sa iya lang gisulti. While ang pikas niingon siya nga iya ang yuta tungod sa iyang gisulti plus napagid siya kanang mga witness bali nga nag-ingon nga 20 years na siya, more than 20 years na siya nga gatikan ang yuta. Sa duha, kinsa man nimo ang katigan kung ikaw bali ang administrasyon kanang ikaw ang tribunal or ikaw ang administrator or officer nga ga-hear sa case. Di katog yung pikas nga naa pa siya lain nga dugang, kaslabi kaning sa pikas nga igo lang sa iyang ingon kay sintilya raman to kaning isa mas substantial man. Okay, kasabot? 5. the decision must be rendered on the evidence presented at the hearing or at least contained in the records and disclosed to the parties affected. So, parehas ang giingon ka ganina, ikan sa ebidensya balik or sa records. Pero kung sa records, dapat gi-disclose po sa party, sa kanang gi-disclose bali sa tanang parties katong record. For example, ikaw police officer ka, kanang gikasuhan ka, for example, na akay lain nga nakay kabit. So gikasuhan ka og conduct unbecoming of an officer. So ang imuhang asawa ang nag-file og kani nga kaso, administrative nga kaso. Pagkahuman sa inyong hearing, niingon ang niingon ang kanang sa tawag ang officer nga nag-render sa judgment, tingon siya guilty ka sa ani nga naa kay kabit. So guilty ka sa kanang conduct unbecoming of an officer tungod kay naami na receive nga information nga nakita mo nga nag-sex sa ani nga babae diyan sa isa ka motel. Pero kadto siya nga kuan on record pero wala girender wala to na divulge sa imuha. Wala po to na divulge sa wala to na divulge sa other party. Sa ila ra to kay gipamanmanan daw kuno kaniya sa katong officer gipadad-an daw kuno ka kuan investigator gisundan ka then nakit-an gyud tuod ka didto nga nag-sex sa hotel. Pero tungod kay kadto siya nga evidence nga nasa records, wala gi-disclose sa inyo dapat dili to admissible kay makakapangdepensa adto, wa man ka natagaan og tsansa nga mo depensa. Okay? So bahala pag unsa ka tinuod bali to ang kato nga ilahang giingon tungod kay belated Manila nga gi-inform sa inyo nag-violate bali ang officer nga nag-render of judgment sa imong right to due process. So dapat kanang disclosed. Di lang contained in the record, dapat disclosed sa parties. Okay? Sixth, the tribunal or body or any of its judges must act on its own or his own independent consideration of the law and facts of the controversy and not simply accept the views of a subordinate in arriving at a decision. Kani importante kay ini. Kaya nga naman, kasagara sa ato ang mga kasagara sa ato ang mga tribunals of offices, actually halos tanan sa government nga agencies kay understaffed. Hindi lang sa korte ang understaffed, apil ang mga offices of government understaffed. So, usually, naagay mahitabo nga ang katong nag-render og judgment, katong officer bali, tribunal or body or judge, kanang maminaw na lang sa unsay giingon sa iya Hindi na niya basahon bali ang kuan ba nga sa iyang own nga kanang independent consideration. So, for example, kasuhan ka lagi adtong gikasuhan ka adtong unsay tawag kanang nakay kabit. Police officer ka gikasuhan ka nga nakay kabit. Then pagkaunsa ang katong igagaw sa imuhang misis naaday nga assistant ni chief katong mag-decide sa kuan assistant day ni chief. Dayon ang katong assistant ni chief mo'y nagsulat sa desisyon. Dili si chief mismo ang nagunsa na. Then iguro niya gipapirma si chief. Dayon ikaw nakabalo ka na nakay proof, nakay ebidensya nga nakuha nga mo din ay gibuhat sa assistant ni chief nga igagaw sa imong asawa. Pwede nimo nga ipa-change ang on appeal imong ipausob ang desisyon based adto nga fact nga walay due process nga nahatag sa imo tungod kay dili man ang tribunal or body or the judge or isang officer ang nag-render adto nga desisyon. Di ba? Igo ra man nga ni kanang igo ra siya nga ni pirma sa desisyon nga gihimo bali sa iyang subordinate. So, na-violate ang imong constitutional right to due process because of that. 7. The board or body should, in all controversial questions, render its decision in such a manner that the parties to the proceedings can know the various issues involved and the reason for the decision. So kani sa decision proper na ta. Ang isa ka tribunal, body, officer, administrator or kinsa nga kanang hear sa case. Dapat ang iyang decision nga himuon dili lang nga niingon siya nga you're guilty. Dapat kinahanglan niya ihatag dito sa iyang desisyon kung unsa ang basihan sa iyang desisyon. Okay? So mobalik ta. Katong kaso for example sa katong nangabit ka. Dapat ang desisyon niya ibutang dili siya moingon nga you because of the charges filed against you, you are hereby found guilty of conduct unbecoming and therefore relieved from service. Dili pwede ingon na. Kinahanglan niya i-allege first kung unsang rules, second kung unsay rules nga gi-violate, third kung unsay proof bali niya adto nga naay rules nga na-violate. Ug ang fourth nga kani bali nga unsa na proof nga katong sa gi-violate ni mga rules is enough to find you guilty of the charges. Dili pwede nga muingon ra siya nga naay guilt nga kanang sa imuha nga part kung dili ni siya based sa saktong rules, sa saktong evidence o saktong burden of proof nga na-meet. Okay? So for example, kani sa burden of proof. Kung igo ra ka moingon siya for example sa imuha nga you are found guilty mo ni nga violation imong gikuan tungod kay ang evidence gi-present sa imuha kay naay nakakita sa inyuha nga nisulod sa isa ka hotel sa kani nga babae. Enough na ba to nga mo convict sa imuha bali sa imuhang offense nga naalay nakakita? Enough na ba to nga burden of proof nga na-surmount? So kana siya nga mga pangutana bali makatabang na sa imuha para ma-overturn ang kaso. Kay kinahanglan man nga i-surmount ang kani nga mga requirements para na i-valid the decision. Okay? So with that, ganita mo example napatay gamay nga time mag-example ta for example sa kanang mga punishable nga offenses nga naa para sa isa ka police officer. Ang isa ka police officer naay around 8 kabuok ka administrative offenses nga pwede siya makasuhan. First is neglect of duty or failure of a policeman to perform his police and legal obligation. Second, irregularities in the performance of duty. Third, misconduct. Fourth, conduct unbecoming of a police officer. Fifth, incompetence. Sixth, oppressive actions. Seventh, abandonment or abandonment sa imong service or loyalty sa government. So, unsa maning mga buta ana ka sa imong pagalingon. Unsa may ako ang mahitabo sa ako kung mo violate ko ani. Mapriso ba ko or okay na nga matangtang ko? Sa tuang jurisprudence niingon nga you can be both. So, pwede ka nga mapriso, pwede pagid ka matangtangan sa serbisyo, pwede pagid ka nga ma-found guilty sa civil nga complaint against you. So dako kayo nga responsibilidad mong gihatag sa isa ka opisyale sa government, di lang police officer. So any violation sa katong kamo isa ka police officer bali, any violation na to 8 ka offenses ga-open sa imong kaugalingon nga makasuhan not only administratively but also criminally and civilly. So matangtangan pa kag trabaho, pwede pa ka makabayad sa danyos sa lain nga mga tao nga naapektuhan sa imong gibuhat, pwede pa gid ka mapriso. So isa ka example, kaning irregularities in the performance of duty. So basically irregularities meaning improper or unlawful nga act done by a cop. Ikaw isa ka police officer, di-station ka sa isa ka area. Naakay nakit-an nga isa ka babae nga hubog gabi ina, imuhang giduulan ang babae kay nakita sa imuha nga naka-uniforme nisalig sa imuha, ningon ka nga, ma'am, ay kabalaka ihatod ta ka sa inyong balay. Oh. So nisalig ang babae sa imuha, isakay nimo sa inyong police mobile, instead nga dadon nimo sa balay, giadto nimo sa kalibunan imuhang girape. Wa hinon nimo gipatay. So pagkamata sa babae, nagkuan siya, nakahinumdum siya nga ikaw nga police officer ang last niyang na hinumduman nga ni assist sa iya, nireklamo siya, gifailan ka og irregularities sa imong performance sa imong duty or kanang misconduct, depende kung unsa imo apply. So gifailan ka og reklamo. Pangutana, pwede pa ba kakasuhan og criminal nga rape kung unsa na nakagifailan na kag administrative? Yes. Ngano man, tungod kay two separate, di man na siya madubol jeopardy kay ang administrative na sanction sa imo is para man sa imong job. Ang criminal para sa imong personal nga liability sa imuhang crime nga gi-commit. Mutana din ka, pwede pa baghapon ko nga kasuhan og civil? Yes. Kung naay damage, naay civil damages nga na-incur bali ang babae, then gusto niya i-split ang civil o criminal nga aspect sa pag-file, pwede paghapon ka makasuhan. So, dili ni ibot ipasabot nga tungod kay nakasuhan kag administrative or nakasuhan ka na og criminal, di na ka matangtang. Mo bitaw nang daghan kag madunggan sa news nga kanang gi-floating status ang gireklamo nga pulis tungod kay kanang naa sila kaso, pending pa ang kaso, so gifailan sila para matangtang sila, gifailan pud sila criminal. Di ba? So, to wrap it up, 1:30 na, to wrap it up, ako na lang i-kuha sa inyo pa. Administrative law, simply put, are the rules that governs not only the internal mechanism of government, but also for the redress or remedy of rights. Not only rights sa citizens, appeal po sa rights ninyo as individuals, as public servants. Kinahanglan ning makasabot ang public officers, soon to be public officers kamo, kung unsa di ay ang administrative law, tungod kay mas grabe mo kahikot ani kaysa any other person. Kay pwede mo matangtangan sa inyong panginabuhi tungod sa any violation ninyo ang ipuhan. So dili lang sa criminal or civil, appeal mo maapektuhan sa administrative ninyo obligations and responsibilities. With that, I thank you, Mano James.
Thank you very much, Attorney Petros Absalon C. Boho, for that very comprehensive and insightful discussion on the administrative law. And of course, I'm pretty sure that the students have really learned some of your very simplified explanations and practical applications of the law. Without so much further, but before that, let us give a round of applause and commendation to Attorney Boho. So kung buhay pa kayo, type in Attorney Boho. So you praise Attorney Boho. Ang di magta-type, mamalasin buong taon ng 2020.
Grabe naman po.
Okay, I cannot see anybody typing in the comment section. So
wala, tulog na.
Nangatulog na ba ang tanan? Of course, no, I'm also encouraging our viewers, our 300 plus viewers in YouTube, to participate and interact with us. You cannot interact through audio, but you could interact through comments. So surely that our speakers will be reading that later part. Thank you so much, Attorney Boho. And we will now be proceeding to our next speaker, who will be giving us the basic and fundamental concepts on the criminal law. So he is also an alumnus of Central Mindanao University in his pre-law. Of course, a graduate also of Bukidnon State University College of Law and a recent passer of the best bar ever. My classmate, and of course, a named partner of Bahian Gascon Tanyola Law Office in Maramag, Kalilangan, and Pangantukan. Ladies and gentlemen, help me welcome Attorney Jovan Branzuela Gascon. A round of applause, please.
Good afternoon, everyone. Thank you, James, for that wonderful introduction. So this afternoon, I will be discussing about the fundamental and general principles in criminal law. So am I loud and clear?
Yes, you are attorney.
So definition of criminal law. So criminal law, the branch of public substantive law, which defines crimes, treats of their nature, and provide for their punishment. So usually, a crime is an act committed or omitted in violation of a public law, forbidding or commanding it. It is a generic term used to refer to a wrongdoing punished either by the RPC or the revised penal code or a special law. So when we talk about crime, you should always remember that it can be an act which is committed. But pasabot imong gibuhat, or act which is omitted or wala nimo gibuhat. So we will discuss about that later on. So the Philippines does not have a common law crimes. Therefore, even though an act or omission is wrong per se, there is no criminal liability if the act is not punishable by a particular provision in penal law or special penal law. Meaning, there is no crime when there is no law punishing the same. So example, when we are in our class, di ba we know that copying the assignment or the exams of our classmates is wrong. It is wrong per se, but it is not. We are not criminally liable if we copy the work of our classmates. Why? Because there is no law which is punishing, or there is no law which punish the act of copying the works of our classmate. So the Latin maxim for that is nullum crimen nolla pena sine legi. So meaning, kung walay balaod nga ga-punish sa isa ka butang, buot pasabot walay krimen nga nahitabo. So bahalag ka pila ka mangupya, since wala may balaod nga nag-ingon nga bawal mangupya o mapriso ka kung mangupya ka, therefore dili ka mapriso misken unsaon nimo pangupya sa imong classmate. So however, not every law punishing an act or omission may be valid as a criminal law. If the law punishing an act is ambiguous, it is null and void on its face. So unsay pasabot ana? So meaning, kung naay balaod atong ibutang si James, si Attorney James, magbuhat og balaod nga magpunish sa mga estudyante nga gapangupya, then ang pagbuhat ni James sa balaod kay walay klaro. Buot pasabot libog. So buot pasabot since libog naman siya or walay klaro ang balaod, therefore it is already null and void. So legal basis for inflicting punishment. So nganong basta makakumit ka og mga krimen, nganong naman gyud mga punishment. So the power to punish violators of criminal law comes within the police power of the state. It is the injury inflicted to the public which a criminal action seeks to redress, and not the injury to the individual. For example, si James, akong kulata, napiyang si James. That is physical injury. Tapos, kung kabantay mo, kung naka-court visit na mo, ang i-file sa korte kay People of the Philippines versus Jovan B. Gascon. Dili, Attorney James Violon versus Jovan B. Gascon. So, mota na mo nga naman na. So, moto ang gibasa ganiha, the power to punish violators of criminal law comes within the police power of the state. So, ang injury kay wala sa kay James, kundili ang injury sa public. So, buot pasabot, para ang uban tao, ang uban estudyante ni James, dili mo sundog sa akua, nga kulatahon si James o piang-piangan si James. So, the concept of mala in se and mala prohibita. So what is mala in se? Mala in se is a Latin word, so which means evil in itself. So definition, a crime or an act that is inherently immoral, such as murder, arson, or rape. Diba, ang rape, murder, o pagpangsunog, kay immoral yun siya, miskin nun sa una to pagbutang. Excuse ha, kigiubo ko karon. Okay, going back, then they are mala in se even if punished under special law, like plunder, which requires proof of criminal intent. So where malice is a factor, good faith is a defense. So example, sa murder, we all know that murder is inherently immoral. Pero kung ikaw ang giunhan og dunggab, nibalos ra ka, nakapatay ka, therefore, since good faith naman ka, dili man ka mandunggab unta kung wala ka gi-actionan og dunggab, so therefore, you are in good faith, then napod kay defense po dayon. So now we go to mala prohibita or prohibited evil. An act that is a crime merely because it is prohibited by statute, although the act itself is not necessarily immoral. For example, example of this is possession of illegal drugs like marijuana. Daghang mga tao, especially mga estudyante, mingit sila nga okay namang marijuana because it's quote-unquote natural, walang halong chemical. However, since gipagbawal man gyud siya sa balaod, it is specifically prohibited by law. Therefore, bahalag moingon ka nga natural ang marijuana, but since na may statute na ibalaod nga gapanish o kung maggunit ka or magkupot og marijuana, therefore, you are already criminally liable. So general rule is that performance of the act itself will constitute the offense. So bahala gigunitan lang na nimo ang marijuana, that is already possession of illegal drugs. So good faith and absence of criminal intent are not valid defenses in crimes mala prohibita. So itong ibutang nga imuhang bag gibutangan og drugs sa imong classmate. Tapos ikaw nisugot ka, sige butang lang diha. So bahala good faith ka, nitabang na ka sa imong classmate, gibutang ang drugs sa imuhang bag. But since possession is already punishable by law, therefore you are already criminally liable. So now we go to Proro Doctrine. So I guess you are familiar with this. So what does Proro means? Wait. Okay. So whenever a penal law is to be construed or applied and the law admits of two interpretation, one lenient to the offender and one strict to the offender, the interpretation which is lenient or favorable to the offender will be adopted. So when we talk about pro reo, always remember that the term that pro reo, so it means that when in doubt, rule for the accused. So kung natay kalibugan sa isa ka balaod, wata balon sa pag-apply, atong pagkonstruan na or atong pag-apply sa balaod kay katong beneficial sa nakasala or sa accused. So unsa may basihan ani? So the basis for this is the fundamental rule that all doubts shall be construed in favor of the accused and presumption of innocence of the accused. So bahalang nadakpan ka nga naa kay drugs or nakapatay ka, you are still presumed as innocent. So penal statutes should be strictly construed against the state only when the law is ambiguous and there is doubt as to its interpretation. Where the law is clear and unambiguous, there is no room for application of this rule. So, si pasabot adto. So, kung klaro na ang balaod, therefore, i-apply na nimo siya kung unsa ana sa balaod. Ayhan na nato gamiton ang pro reo kung naay kalibugan sa balaod, kalibugan ug unsaon pag-apply. So now we go to equipoise rule. So when the evidence of the prosecution and the defense are equally balanced, the scale should be tilted in favor of the accused in obedience to the constitutional presumption of innocence. So kabantay mo, di ba? Kung we talk about law, there is always a scale na ay timbangan. So kung ang ebidensya sa prosecution o ang ebidensya sa nakasala kay mao-mao ra kabugat, ang balaod or ang judge kay mupabor dito sa nakasala kay tungod sa equipoise rule o tungod sa presumption of innocence. So now we go to applicability and effectivity of the penal code. So first we have general, territorial, and prospective. So on generality, so general rule, penal laws are obligatory on all persons who live or sojourn in the Philippine territory, regardless of nationality, gender, or other personal circumstances, subject to the principles of public international law and to treaty stipulation. So what does that mean? So bahala pag Amerikano ka, African, Argentinian, or unsa pa imong nationality, basta naa ka sa Pilipinas, ikaw covered sa mga penal law sa Philippines. So bahalag Amerikano ka, kung mupatay ka diri sa Philippines, you will still be held liable under our penal laws in the Philippines. So since there's a general rule, nagyud na siya exception. So unsa may iyang exceptions? First, those exempt from criminal prosecution by virtue of, first, the universally accepted principles of public international law, such as sovereigns, head of states, ambassadors, charge the affairs. Then B, treaties and treaty stipulation, and C, laws on preferential application. Excuse ah. Okay, going back. So sa exception. So kung naay mga ambassadors nga mula sa ani sa Philippines, bahalag makasala sila na sila exemption. Example po sa treaties and treaty stipulation kay ang sige, unya na lang i-discuss. So after sa generality, we'll go to territoriality. So general rule, penal laws of the country have force and effect only within its territory. It cannot penalize crimes committed outside its territory. The territory of the country is not limited to the land where its sovereign resides, but includes also its maritime and interior waters as well as its atmosphere. So unsay pasabot adto? So general rule daw, kay example ako, I am a Filipino. Pero if muadto ko sa United States of America, kami ni James muadto mi didto, kunya kulatahon no si James, physical injury. So dili ko mapanish sa criminal law or penal laws diri sa Philippines. Kay naman ko sa US, I am outside the jurisdiction of the Philippine penal laws. However, since naman ko sa US, ang US nga penal laws ang mag-sanction dayon sa kuha. Pero gawas ng Philippines. Kay nakumit man ako ang crime kay sa US man. So muna siya gawas na siya sa territoriality. So exemptions. Crimes committed on board a Philippine registered vessel or aircraft cruising on international waters or airspace. Crimes involving counterfeiting or forging of coins or currency notes or introduction thereof into the Philippines. C, crimes committed by public officers while in the exercise of their functions. D, crimes against national security and the laws of nations under Article 114 and 123 of the Revised Penal Code. Excuse na po ha. So unsay may exemptions adto? So kung naay crime nahitabo sa Philippine registered nga vessel, example sa tugo nga barko, naitugo ato ibutang na example, tugo nga barko padulong mi sa United States. So tunga sa Pacific Ocean, akong gikulata si Attorney James. So although ang crime kay na-commit gawa sa Pilipinas, but since gi-commit man siya sulod sa barko nga nakarehistro sa Pilipinas, therefore I could still be held liable under the penal law of the Philippines. So B is crimes involving counterfeiting or forging of coins or currency notes or introduction thereof into the Philippines. Example na pod, kami gihapon ni Attorney James na naman mi sa US. So dito sa US, nagpa-print mi og mga kwarta, mga 1,000 peso bill. Tapos amo din gipaship sa Philippines para dito ibaligyan namo ang fake nga mga kwarta. So bahalag sa US to namo gibuhat ni Attorney James ang pag-counterfeit sa Philippine currency. Ma-punish gyapon mi sa Philippine law kay tungod kay isa man siya sa mga exception. So C, crimes committed by public officers while in the exercise of their function. Katong giyon ganiha, di ba nga, at ibutang si James ang president sa Philippines or ambassador na lang sa Philippines. Si James ang ambassador sa Philippines into the United States. So si James, nakakommit siya og crime dito sa US. So since he's a diplomatic member, therefore, bahalag ang crime na nakomit niya kay sa US, since he is a public officer in the Philippines and performing his function, therefore he will still be held liable under the Philippine law. So prospectivity. So say prospectivity. Prospectivity means looking forward. So general rule, acts or omissions will only be subject to a penal law if they are committed after a penal law has taken effect. So what does that mean? Di ba ganiha nag-ingon ko nga ang pagpangupya kay dili siya criminal act. So it is not punishable by law. Katay butang nga naay legislation nga gi-criminalize ang pagpangupya. Kunya atong law school pa mi kay kinupyahay man mi ni James. So balag kinupyahay mi ni James atong law school pa mi kay since atong una pa man siya, so dili mi ma-punish. Ang ma-punish lang dayon kay katong mga gapangupya kamo, mga masadyante kung mangupya mo after na buhat tong balaod or after the application of the law. So conversely, after omission which have been committed before, the effectivity of a penal law could not be penalized by such penal law. So matong explain ganiha. Exceptions, penal laws shall have a retroactive effect insofar as they are favorable to the person guilty of a felony. So di na to siya discuss. So those which establish conditions that are favorable or lenient to the accused. Next. So significant constitutional limitations on the power of Congress to enact penal laws. So no person shall be held to answer for a criminal offense without due process of law. So di ba gistorya na to ni Attorney Petros ganiha ang due process of law. So dili ka pwede mapriso kung dili ka maatubang sa korte. So excessive fines shall not be imposed, nor cruel, degrading, or inhuman punishment inflicted. So mo ni siyang wala na'y death penalty. Kay death penalty is considered as an inhuman punishment. So no person shall be imprisoned for debt. So walay tao nga mapriso tungod kay palautang siya. Pero makagaba kung mangutang ka, dili mo bayad. So no ex post facto law or bill of attainder shall be enacted. So what is an ex post facto law? So an ex post facto law is one which provides for the infliction of punishment upon a person for an act done which when it was committed was innocent, a law which aggravates a criminal or makes it greater than when it was committed. So example, katong, di ba, katong aong gi-admit nga kinupyahay ni James sa una sa law school. So kung naibalaw ibutang nga kung nangupya ka sa law or kung gapangupya ka sa mong classmate, mapriso ka for 1 year. So kami ni James, gawas na miya to. Kaya itong una pa matunaw mo na buhat. So, Bill of Attainder. A Bill of Attainder is a legislative act which inflicts punishment on individuals or members of a particular group without a judicial trial. So, say pasabot ana. So, Bill of Attainder kay example mo magpagawas og balaod ang Congress nga ipanish nila tanan nga mga red-leaning or mga NPA. So dili siya pwede nga katong balaod. Kaya gibot ato balaod kay gipanish man niya tong specific group atong NPA diretso nga wala na judicial trial. So paspasan na ako ha kay murag 6 minutes na lang. So felonies and criminal liability. Crime. Crime whether the wrongdoing is punished under the revised penal code or under a special law. So when we talk about crime, this is generic. Okay, so kung felony dayon refers only to the violation of the revised penal code. So kung nakasala ka, example murder or rape, ang tawag ada felony. Tawag sa imo felon. Tapos offense is the proper term for a crime punishable under a special law. So, offender, offense. Example ani kay illegal possession of firearms. Tapos misdemeanor, a minor infraction of the law such as violation of an ordinance. So muna siya ang kalahian. So don't be confused ha. When we talk about crime, general na siya. Pwede na siya applicable sa revised penal code, sa special laws o sa violation of ordinance. Kung felony gali sa revised penal code na siya, kung offense kay under special law o misdemeanor kay sa ordinance lang. So felonies, act or omission punishable by law are felonies. So again, acts gibuhat nimo and omission wala nimo gibuhat. So felonies are committed not only by means of deceit intent na kay gituyo nimo, but also by means of fault or culpa, gadinanghag ka. Wato na gitawag nga reckless imprudence resulting to homicide or multiple physical injury. Kaya tungod sa imong kadanghag, nakasala ka, nakasakit ka sa lain. Ang kalahian na yun sa deceit, kay deceit is when the act is performed with deliberate intent. So gituyo gid mo siya. So ang fault, kung dinanghag ka. So general elements of felonies. So an act or omission. So when we talk about act, any kind of body movement which tends to produce some effect in the external world. So includes possession. So possession of firearms or illegal drugs. So omission, the failure to perform a positive duty which one is bound to do under the law. It is important that there is a law requiring the performance of an act. There is no positive duty, there is no liability. So, committed by dolo or culpa and punished by the revised penal code. So, earlier, nagstorya man ko nga, unsay mga balaod nga, kasuhan ka, bahalag, wala kay gibuhat. Example, ani is misprision of treason. So, kung nakabalo ka, nga na ay mga grupo sa tao nga gaplano nga mag-conduct og treason, then meaning you are already held liable. Kay it is our duty as a citizen of the Philippines to protect our sovereignty. So kung naay mga treasonous act nga gaplano, mga tao nga gaplano mag-conduct or mag-commit og treason, tapos magilumilom na ka, you can be held liable for misprision of treason. Also, abandonment of person in dangers and abandonment of one's own one's own victim. For example, nakita bata naligsan gi hit and run. Tapos di tanaw ra ka wala ka ni tabang wala kay may tawag og pulis. So, pwede gyapon ka ma-held criminally liable ana unsay kaso sa imuha abandonment of person in danger. So we also have stages of execution of felonies. First, we have attempted. Second, we have frustrated. And third, we have consummated. So, unsay kalahian sa tulo? Murag last slide na day ko ni murag 30 minutes na. So first, attempted. So when the offender commences the commission of a felony directly by overt acts, but does not produce the felony by reason of some cause or accident other than his own spontaneous desistance. So, other than his own spontaneous desistance. So, example, ani, naisa ka tao si A. Iyang dunggab si B. Pag dunggab niya kay B, iyang gusto gina patyo niya pero natapsingan lang. So nasugdan na niya og patay unta kay B. Kaso wala na tiwas og patay si B kay nganuman kay there are some reason of some cause or accident other than his own spontaneous resistance. So since nakalikay man si B, so wala na matay si B. So matong gitawag nga attempted. Kay gisuwayan niya pero wala niya na tiwas tungod kay na ay other factors or other reason nga nag-cause nga wala niya na human ang execution sa crime. We also have frustrated. So when is a crime frustrated? So when the offender performs all the acts of execution which would produce the felony but does not produce it by reason or of causes independent of the will of the perpetrator. So independent of the will of the perpetrator. Example ani kay si A gidunggab niya si B. Pag dunggab ni A kay B wala kalikay si B. Pero instead of pagdunggab kay sa heart gidunggab unta naigo lang sa ribs wala nakalahos ang pagdunggab. So it is already frustrated. Kay nganuman gi-attempt naman yun niya og igo ang vital organ ni B. Kaya kung naigot to, ang heart yun ni B, wala nasangit sa ribs ni B, ang kutsilyo, na-consummate na ginunta to ang crime. Pero wala man siya na-consummate by reason independent of the will of the perpetrator, kaya pagdunggab niya, nasangit sa ribs. So that is already frustrated. So consummated, when all the elements necessary for execution and accomplishment are present, the felony is produced. So consummated, kung si A, pagdunggab ni A kay B, naigo yun ni A ang heart ni B. So that is consummated na nga murder. So I guess this would be all. Thank you, James.
Thank you very much, Attorney Jovan. And if alive pagyapon ang ato ang mga participants and our audience here sa Zoom and sa YouTube, kindly type in Pretty Jovan. So of course, kailangan nato i-appreciate ang pagka-pretty ni Attorney Jovan. So type in Pretty Jovan or mamalasin buong taon sa love life. Kung may love life na, magkakaroon ng masayang third party. Of course, no, wow, from Attorney Von, he is typing Pretty Jovan. So we are receiving here a lot of messages containing Pretty Jovan. Okay, so it was indeed a very simplified and useful ang mga discussions no, ni Attorney Jovan, and our students are actually taking notes. They are jotting down important details because that's part of their outputs for this particular endeavor. Now, without so much further ado, of course, no, nahumana nato ang administrative, and then nasulod na po nato ang basic and fundamentals of criminal law. Let us now touch the special penal laws by a very pretty, very young and promising lawyer of the country. She was my former student in Central Mindanao University, a graduate of Bachelor of Arts in Political Science, and also a graduate of Juris Doctor at Bukidnon State University, a recent passer of the best bar ever, a associate of Monsanto Gamboa Law Offices. Ladies and gentlemen, to discuss us with special penal laws, we have Attorney Yola Magdalene T. Diana. A round of applause, please.
Char. Hi, everyone. I'll be discussing about some special penal laws. So since these special penal laws, under our law in criminal law, under diri sa Pilipinas, no, naay duha ka balaod. Those that are covered by the revised penal code katong gina-discuss ni Attorney Jovan, no? Madunggan na ba ko?
Yes, Yol. Continue, please.
Then the one is the special penal laws. Kaning special penal laws, these are laws not covered by the revised penal laws. So, muna siya, mong ginatawag sila nga special, no? So, I'll be discussing about the Republic Act number 11313 or the Bawal Bastos Law. This law was enacted in 2019, no? Under the administration of President Duterte. So, I'll be discussing this law since it is murag kanigid siya nga balaod if dili gani wala pa kayo kabalo ang tao nga ila ring ginabuhat di tumao. Dili to sakto ug dapat katong ilang ginabuhat di ay ug tinud-on to sa mga biktima, they can be held liable and with fines or even imprisonment, no? So I'll be discussing this Bawal Bastos Law. The first is, mo ni siya, kana bitong mag, psst, psst, hoy tumboy, bayot. Kana bitaw nga mga remarks sa isa ka tawo. It is covered by this Safe Spaces Act, or an act defining the gender-based sexual harassment in streets, public places, online, workplace, and educational or training institution, and providing for the measures and penalties thereof. So kani siya nga mga remarks kay sa ingon sa tong balaod is most likely dili day ni siya pwede. Sala ni siya. So kani siya, it covers all forms of gender-based sexual harassment. So tanan-tanan nga mga sexual harassment, masking sa dala nalay mo ingon sa imo nga bayot, that is covered under this law, no? So it is a gender-based sexual harassment committed in public places, example malls, street, alleys, public parks, schools, building, bars, restaurant, tanan gyud nga inyong makit-an nga public. And then it can be kani nga mga acts pwede ni siya sa public places, sa educational institution, and even in your workplace. So kani sila nga mga acts. So these are under this law a form of sexual harassment, a gender-based street and public spaces sexual harassment. The number one, the most common, and the second one is the gender-based online sexual harassment. Online nga pag haras sa imuha. No, kanang mga send og kuan diha bi, send og mga ingana, sige na miga. Mga ingana siya nga mga thoughts, no? Next is a sexual harassment in the workplace, sa inyuhang ginatrabahuan. And the next is a gender-based sexual harassment in educational and training institution, sa inyuhang eskwelahan mismo. Gakadungog mo ani ug daghan kaayo ni, no, nga mga panghitabo. It is so common. So we will be discussing this one. Number 1 is a gender-based street and public spaces sexual harassment. How is this committed? It is committed through any unwarranted and uninvited sexual actions or remarks against any person, mababae man or malalaki. No, unsa man ang imuhang gender preferences sa ngalan nga it is para sa imo, it is a violation sa imuhang safety and it is surely unwarranted sa imuha man. Kay kinsa gyud ganahan, miss, sexy kay ka miss, mga ingana nga mga remarks or any regardless sa imuhang motibo, regardless gyud siya. So if moingon lang ka nga man ako to siya gituyo nga ignan og sexy kay sexy man gyud siya, regardless ana ang atong balaod wala ta ginakwanan ana. So regardless gyud nga masking sexy man gyud siya, murang gingana nimo. Pero ang ingon sa balaod, wala milabot sa imong intensyon basta kay katong offended party na feel niya nga, hala, gibastos gyud ko ani nga tawo. Basically, appeal gyapon ni siya sa coverage aning ato ang balaod. So regardless kanang mga bitaw makita nimo magbaklay ka, either lalaki or babae ni siya hab. Kinsay mga perpetrators ani even mga lalaki kanang group of boys, girls ug nay mag diya sa dalan miingon dayon nga, hi miss, hi chicks, agupuha oy, mga ingana nga mga example of which is the catcalling. Appeal na siya, catcalling kanang wolf whistling kanang wit-wiw kanang mga ingana. Appeal na siya ani nga balaod. So unwanted invitation, misogynistic, transphobic, and sexist slur. Example, bayot, tomboy. Mao na siya nga mga istorya kanang sa dalan and in public places. Statement of sexual comments and suggestions, verbal and physical that is unwanted and has threatened the one's sense of personal space and physical safety sa imuha mismo. And persistent uninvited comments or gestures on the person's appearance. Example, pangit. Ignan kagingana. Pangit. Relentless requests for personal details. Example, nilabay lang ka. Miss, mga kog number B, please, sige na miss, sige ganaon ka. It is covered under this law. It is prohibited and you can be penalized under this law. No? It may be committed in, man ni siya pwede ma-commit? Sa tanan gyud ni siya public places tanan public places, even malls, restaurants ug man galing mo sa ngalan nga it is public, then you can be held liable with this one. The next is gender-based sexual harassment in restaurants and cafes, bars. Kaya most likely nagya pay kahitabo nga mga ingana no kanang sa mga cine, malls and otherly private masking privately owned nga lugar basta it is open to the public, dapat kana sila nga mga establishments, they should adopt a zero tolerance policy. Meaning dapat dili ilahag yun dapat ng if na ay perpetrator, dapat ilahan ng i-apprehend, ilahan ng pwede in flagrante delicto, ilahan ng dakpon, then investigate the situation. Dapat ingana. And it is required under these laws that kakani nga mga restaurants na agyo dapat ni sila signage about ani nga balaod. Na ay signage ani, na atay kanang CCTVs, in case nga if naay kaso dali ra mahatag ni sa korte, no? And it is naapod ni, it is so common a gender-based sexual harassment in public utility vehicles. Example of public utility vehicles are kanang buses, kanang jeeps, kanang mga relas, mga ingana nga mga public utility vehicles. Ang giingon ana is if it is a example kana gani mga driver, no? Kanang mga driver nga nag-agi lang ka sa dalan. Gitsitsita na ka. That is against the law. So the LTO may cancel the license of the perpetrator. So katong mga grabing Miss, hi Miss, may number kana, most likely if they are public utility vehicle, most likely if they are the drivers, no conductors, the LTO may cancel the license of the perpetrators, and the LTFRB may suspend or revoke the franchise or transportation of these operators because it is considered as a breach of contract of carriage. Why? Ngano mo kayo, ngano na breach of contract of carriage mani nga ang nakasala raman is the driver mismo or ang konduktor. Ingon sa balaod, it is presumed nga ang tag-iya ato, example, pabama o rural, no, example, ani diri sa ato nga if naamanggali mga drivers nga committed this crime, a perpetrator, for example, a perpetrator, no, ang ingon sa balaod ani, there is a breach of contract of carriage between you nga ikaw biktima o ang katong the operator mismo, ang tag-iya mismo, ang kumpanya. So the law, since ginahatagan og protection ng ato ang mga tanan tao ni siya regardless sa imong gender, if you are feeling violated or harassed by anyone, no, if example in public utility vehicles, there is a breach of contract of carriage because you are presumed to be negligent in the supervision sa imuhang mga empleyado nganong walay batasan ang imuhang mga empleyado. Mao na siya. So there is a breach of contract of carriage kay supervision nimo nganong wala man na sila'y batasan, nganong ingani man nilang batasan o makakitag babae nga sexy, hala witwi wala may kog number miss ka sexy oy, ingana nga mga remarks, that is prohibited under this law. So next one, no, it is since ang kato, this gender-based sexual harassment, it is a public, no, public tanan, public spaces nga inyong makitaan. This if naamod diha anang example sa park, gipang sitsitan mo, it is against the law. You can go to the PNP or the police station to report that incident. And most likely tanan gyud na gihatagan og kanang obligasyon ang tanan establishments nga dapat atuning ipatupad nga balaod, since this is the most common crime, no, nga murag ay naa din nga balaod mga ingana. So dili lang siya ingon sa public places, even online, no, even online sexual harassment. Example of which is kanang mo-send ka og message sa imuhang mga ingon ta sa imong kaila, mayon ka nga hatagi ko og kuandi kanang sexy nga picture, that is against the law, that is against this one. So through physical and emotional or psychological unwanted sexual misogynistic transphobic homophobic tanan ichatan kag bayot, that is considered as it is illegal and it is under this gender-based online sexual harassment. Online siya. Most likely ang mga comments and mga remarks nga ginakuan sa imuha, it is most likely online sa kanang mga imuhang cellphones, sa imong computers, most likely nga na. Any forms of media that contains photo, voice, video, most likely naapod tay bag-o nga, naapod tay balaod ani, no, sa una ra pod katong daghan ta cyber libel mga ingana. So depende na sa imo ha og unsa nga mga kaso ang pwede nimo i-file or i-kuan nimo dito sa korte. So the next one is qualified. When we talk about qualified gender-based street, public spaces and online sexual harassment, meaning ani imuhang sala or imuhang penalty mas mudako pa, no, mas mudako pa. Example, imuhara untang pa, example ha, if imuhara untang fines is ingon ta 1,000, since imuha ni silang gibuhat kani nga mga acts, your penalty will be next higher in degree. So depende na dayon na if naato siya na ay imprisonment, ingon ta 1 to 20 days. Example lang siya. So no, qualified siya if the acts takes place in a common carrier or public utility vehicles. Kato akong ginaingon nga o nagkamulo siya sa kuan na nabuhat to nga crime sa bus, anang mga jeepneys, no, public utility vehicles, included but not limited to any mga tricycles, mga where the perpetrator is the driver of the vehicle and the offended party is the passenger. And if the offended party is a minor, bata, a senior citizen ang imuhang gibastos, or a PWD, or a breastfeeding mother nursing her child, kana imong gibastos ng mga bata, imong penalty is next higher in degree. So mas mo grabe ang imuhang penalty ana. The next is if the offended party ang imuhang gibastos mismo has a mental problem. So tending to impair their consent kanang dili gid kaayo siya makahatag og consent, it's either naa siya mental difficulties, no? So the next one is if the perpetrator is a member of the uniformed service such as the PNP, kani sila ang mga nang bastos mismo sa imuha is a member of a uniformed services. So kamo puhon-puhon mga criminology students, no, dapat kabaluta sa balaod, dapat dilita, even your students, dapat dilita mo yung ani, kay it is regardless sa imuhang gender, no, you can be held liable in this special laws. The next one is we take places in the premises of a government agency offering frontline services to the public, og mismo kani nga pangbastos nahitabo gyud sa nahitabo sulod sa isa ka government agency. So grabe na gyud siya nga pangbastos. No, it is considered qualified, so meaning imuhang penalty is higher in degree. So it is, the next one is the gender-based sexual harassment in workplace. Kani siya, kani nga mga gender-based sexual harassment sa inyuhang opisina mismo. Kana bitong mga lain na nga mga gestures nga ginahatag sa imo, like sige na kag gunit-gunitan, kuanan kag text messages sa imo mga kauban, like moingon nga kanang may feel gid nimo nga bastos gid kaayo silang mga intensyon. Regardless pud gid na siya silang intention ha, maski may uy seksihan nimo karon gitextan ka na, if you're feeling offended by that, you can file a case against them. So kani siya kanang mga text messages, electronic mails through forms of information and communication that has caused detrimental effect of the conditions of individual employment. Meaning sige ra kay nga ka-sexy nimo oy, ma-conscious na dayon ka, lahi na din yung pananaw, murag na trauma sa imuha mismo, di ba? The next one is this. It is committed in a conduct sexual nature and other conduct based on sex affecting the dignity of a person which is unwelcoming, unreasonable, offensive to the recipient, whether done verbally or physically, masking gistorya lang nimo, all through the use of technology such as text messaging or electronic mail or any other communication system. And this kana nga mga kato nga mga acts in workplace, no, tanan good, most likely cover niya tanan. If feel nimo ikaw offended party, they are most likely degrading you even verbally or physically, there is a sexual harassment on your workplace, they can be held liable to this one. So the next one is the gender-based sexual harassment in educational institution. Kaning mga harassment nga sa eskwelahan mismo gakahitabo. So it is most likely committed against one who is under the care, custody, and supervision of the offender, against one who's education, training, apprenticeship is entrusted to the offender, kanang mga estudyante ug ang iyahang maestro or maestra. When the sexual advances resulting in an intimidating, hostile, or offensive environment for the student, trainee, or apprenticeship. So who are principally liable ani if sa eskwelahan ni nahitabo nga mga crime? No? The gender-based sexual harassment in educational institution may be committed by principal, school heads, teachers, instructors, professors, tanan who has authority, influence, or moral ascendancy over another students and trainees. However, this one, if the offender ang mismo ang nangbasto sa imuha, estudyante gyapon. Ug ang estudyante gyapon nimo ang nangbasto sa imuha, they can be held liable for administrative sanction by the school as stated in the school handbook without prejudice sa right sa isa ka eskwelahan if upon investigation dadto nga halalaing gini siya batasan, mao gid ni iyang gibuhat sa babayi or sa lalaki or anything related to that perpetrator pwede sa eskwelahan strip ang iyang diploma or even issue an expulsion order. Ipahawa siya sa eskwelahan. Mauna siya sa mong mas grabe gyud no ang kaninga balaod. So cover gyud niya tanan regardless gyud cover niya. Duties of the educational and training institution under the law. So kani sila nga mga eskwelahan dapat nasin sila designate an office in charge to receive complaints. So dapat kani nga eskwelahan na ay ingani. Dapat gyud mao ni siya ang giingon sa balaod and shall ensure that the victim are provided with gender sensitive environment that is both respectful to the victim and conducive to truth telling. So dapat kani siya tanan eskwelahan naon tay ingani no kay most likely daghan ga kahitabo nga mga harassment sa eskwelahan, workplace or anything, but most likely lain gyud siya sa eskwelahan mismo ga kahitabo. And it is the duties even if ang estudyante dili siya mo complain, dili siya mag-file og complaint, adit na lang ko kay mahadlo ko. No, it is the obligation sa isa ka eskwelahan nga imbestigahan ang nahitabo and dapat naa sila'y mga informations ug tanaw nila og unsa gyud ka tinuod ang mga panghitabo og para makatake sila appropriate actions ana to resolve the situation, and it is most likely detrimental atong sa victim kay naagay trauma. Most likely if ang perpetrator is iyahang teachers or most like na moral ascendancy sa iyaha. So the other salient features is that the restraining order, if makatagan ka ni sa korte, restraining order kato imong perpetrator masking si kinsa man to sila regardless, pwede ni sila matag restraining order, meaning dili sila kaduol sa imuha. Psychological and counseling services, hatagan ni ang mga biktima because it may cause trauma to them. Kay dili man tatanan isog og like grabe gyud ka kuan ato ang kuan no. Like koy labot ana ang uban ana nanay trauma sa ila like ignan na sila wait sexy kay ka na grabe imong shorts sunod ana di na ganahan mo gawa sa ilang balay because of trauma. So they need psychological and counseling services. And the confidentiality, so tanan nga na nga panghitabuan ni it must be confidential between atong victim and katong schools or anything, because if example if halagi kuan biya na siya ni kuan ay ni sir ni ana ni ma'am ni ngana, di ba ang estudyante most likely mundang na lang no mas kadaot pa gyud noon sa iya ha, di ba? So that's all in anti-bastos law. So we will be discussing further the RA 9262, the Anti-Violence Against Women and Their Children Act of 2004. Kani siya daghan na gyud kayo mo madunggan ani labunag pang kuno ang babae, pasakitan, abusuhon, most likely hala ipabawsi gud kana niya. So atong kanon is what is bawsi? Kung kanang unsa din ning bawsi na hala ipabawsi gud kana niya ba? Imong gipasakitan hala, imong gitag kwarta hala, ipabawsi gud kana nila. Most likely ang mga marites mo na ingon, di ba? So atuan nang i-discuss today. So Anti-Violence Against Women and Their Children Act of 2004. So what is the violence against? Unsa day ni siyang bawsi? No, it refers to any act or series of act committed by an intimate partner. Intimate partner, husband, most likely imong bana, imong ex-husband, live-in partner, boyfriend, girlfriend, fiancé, who the woman had sexual or dating relationship. So, mo ha, girlfriend, ano na-appeal? Because cover gyapon og na ay sexual relationship ang bae to babae. Sabdan, provided there is a sexual or dating relationship between the two. So it is committed against a woman who is his wife or former wife. Nagbulag na sila or ihang asawa karon. Against a woman with whom the person has or had a sexual or dating relationship. Masking human na, wala na sila, nagbulag na. Pwede pagyapon ka makover aning bawsi. No? Against her child, or against the women with whom he has a common child. Child, kanang naa siya'y anak dito, masking dili sila minyo. No? Against her child, whether legitimate or illegitimate, within or without the family abode, masking wala gapuyo sa imong balay, og imo nang gipasakitan, you can be held liable for vowsy, of which the result is more or is more likely to result a physical, sexual, psychological psychological harm or suffering or economic abuse, including threats, battery, coercion, harassment, or arbitrary deprivation of liberty. So unsa di ang mga acts of violence which are covered ani? Unsa dito nga mga kanang mga acts ingon ang balaod, ingon aning 9262 nga makaingon ka nga you can be held liable. Ana ang kaninga balaod na ay upat. The first one is the physical violence. Kanang this include bodily or physically harm. Example is imuhag yung pasakitan, like imong sumbagon, imong kulatahon ang babae, or imuhang partner which naa kay sexual relationship, even wala na or sa una pa. Sa ngalan nga naa kay sexual relationship, ana og imuha siyang gipasakitan, kay ingon ang balaod, maski pang dugay kay ito nahitabo, provided, ingon ta, the prescription period ani is 20 years. Now, maski pang dugay na kay mo bulag, you can be still held liable in this if, ingon ta, last year pa ni mo gibuhat, karon pa siya nag-file, pwede gyapon ka pakasuhan ani, no? Kay it's 20 years man iyang prescriptive period. Kaning physical violence kanang most likely kana makitaan bitaw gid ninyo sa mga koan, kanang mga news nga battered women syndrome nga may ngana kana bitaw ginakulata ang babae, ihang anak, apil ihang anak ani ha, the sexual violence kanang even if imuha minyo na mo og imuhang pugson ang imuhang asawa, that is considered rape, marital rape, and you can be held liable under 9262. It is a violence against women gyapon. Sexual violence. Any tanan gyud nga most likely tanan kaning bawsi covered gyud niya halos sa tanan, no? Even the physical, the sexual violence, no? Kabalo na ta ng mga sexual violence. Ang psychological, diri ang psychological. Example ani ang pinaka common is kana bitong mga bit ang imuhang bana. Mga bit imong bana or mga bit ang imuhang partner, no, ay nakaanak pa jud. That is most likely psychological violence against sa imuha babae. Why? Because there is a mental or emotional anguish, no? Murag emotional abuse on the part of the offended party nga na siya'y lain, ang kani siya ma-prove ni siya upon sa imong testimony sa court. Moadto ka dito sa court, istoryahan na nimo. And depende na din na kan judge if there is a reasonable ground to believe that there is a psychological violence. And from the facts and the circumstances of each case, mabalaan na to na dito. The next one is economic abuse. Acts that makes or attempt to make a woman financially dependent upon her abuser, kanang dili manghatag og sustento sa bata, sa imuha, kana siya, it can be covered under this economic abuse. O kanang mga babae bitaw dili ipatrabaho sa ilahang bana, kanang diha ra mo sa balay, that can be considered as an economic abuse. Controlling women's own money or property, ikaw magkupot tanan, or ikaw naragyod ang magsuli, control the conjugal or the common money or properties, dili nimo hatagan ang imuhang asawa or ang imuhang partner. So you can be liable for economic abuse. Destroying or even destroying household properties can be an economic abuse under this 9262 law. So who are protected? Who are the persons protected under this 9262? Kinsa di ay ni sila nga mga tao? It can be the wife, asawa mismo, former wife, a woman with whom the offender has or had a sexual relationship with, a woman with whom the offender has a common child with, and a legitimate or illegitimate child to whom the woman within or without the family abode. So tanan gyud ni siya cover, even if anak ka sa gawas or hindi pa sakitan mismo ang anak sa gawas, mismo ikaw gyud anak nga legitimate anak, pwede gyapon ni siya. It is violence against women and their children man pud ni siya. So cover gyapon, pero naa gyapon tay child abuse, no? Pero if most likely if naa tong mga elements sa crime, sa vowsy gyud na nila gina-file. So, is vowsy committed by men alone? Mga lalaki ra ba ang makasalaan ni? Or pwede makakuan ani nga krimen? No, women can also be held liable under the law. So, lesbian partners and girlfriends or former partners of the victim with whom she has or had a sexual or dating relationship. So, kanang babae to babae, as long as namoy sexual or dating relationship, masking babae ha, pwede ka makasuhan og vowsy. Dili kay, ay, panglalaki raman. No, pwede gyapon na sa babae. Lesbian partners or girlfriend, basta naa sila sexual or dating relationship. So, kinsa may maka-file aning complaint? Tanan na, any citizen masking silingan ra ka. If you have a personal knowledge of the circumstances involving the commission of the crime, you may file a complaint because it is a public crime. It is not a private crime, so it is a public crime. Tanan. So, bali, bisag kinsa pa ka, ikaw marites kay kadiha, mo file ka ani nga kaso, pwede gyapon ni siya. No? Kaya most likely, ang uban na babae, mahadlok, manggod, mahadlok sila, basin na threat sa ilahang life, sige, sumbong, at yun mga ingano. So most likely, ang mutabang ana, ang kanay imong mga silingan. So, the next one is, naamang gud ni sa ato ano ka, ang uban ani pabarangay panmasla. Can the barangay officials mediate or conciliate kana bitaw? Naanagi, laparon na ka, gisumbag-sumbag na ka didto, nga ay pagkuan na lang mo, paghusay na lang mo sa barangay. No. Dili na siya pwede. Dili na siya pwede. Conciliation on mediation of the acts of violence against women and their children are not allowed under this law. So dapat kani sila, dili sila mo mediate or mo influence. Ilaha lang ani is muhatag sila protection order or ilahang mo-assess sila ani sa babae. Dapat tingana lang, dili kay magbuot-buot silang ayaw na ninyo i-file oy kay kuan naman ninyo kanang away-away ra man ni nga mag-asawa. No, dili na siya pwede, dili na siya allowed sa ang atuang balaod. So if naamoy nakitaan nga mga ingana nga mga incidents, it is not allowed, and kaning mga barangay officials dapat dili sila maglabot-labot. Ilaharang gyud dapat ani mo assist lang mo sa unsay nahitabo, no? Kay since dili man kamo ang korte, the court ang kaning. And if mag-file ka nino, hatagan ka og temporary restraining order, barangay protection order, mga order nga gihatag sa korte ana or even the barangay. Kani sila og mo mag-file na ning mga babayi, most likely kuanin ni sila na sila mga protection order, meaning ang kaning mga lalaki or lang sexual partners dili na maka-ilabot sa ilaha. So that's all for special penal laws, no? I hope nga nakasabot mo. Pasasakay ko.
Thank you very much, Attorney Diana. And for our audience and our students, if naamoy nakatunan so far sa 3 na to ka speakers, type in blessed. Kay kung dili mo type in og blessed, ang maglisod kita ka blessed ani for the next coming years. Okay? Humana mo og type in og blessed. Kung nahumana mo og type sa word nga blessed, o kung nanagin mo natunan, kay musuluray na ang next na speaker, ibutang ninyo nga nasudlan na. Ang pasabot ana, nasudlan na og knowledge ang atoang brain. Kay ang atoang next na speaker, musuluray na. Type in, nasudlan na. Okay? Comments both in Zoom and in YouTube are flooding out, no? Ang word ginasudlan na, ang phrase ginasudlan na. Oy, i-type in po ni Attorney Von ang mapriso ka. So grabe ka maunuron ang discussion ni Attorney Yula, no, pertaining sa ato ang anti-bastos law or Safe Spaces Act, including the vouching. Although daghan kayo tag special penal laws nga dapat ba, pero kulang kayo ang oras ang opportunity, and we are hoping that we could sustainably do this kind of activity, no, for academic purposes. So thank you so much, Attorney Yula, for such comprehensive and kanabitang grabe ka on sa clear ang discussion on the law. The appreciation of the law nga wala kayo na tagaagpagtagad, for sure nasudlan na. Kay sige gyapon og type ang mga estudyante og nasudlan na. Kay kung dili mo type og nasudlan na, sunod tuig kamo ang masudlan. Char lang. Okay. Thank you so much, Attorney Yola, and virtual a round of applause for our very pretty and brainy lawyer, Attorney Yola Diana. And now, without so much further ado, let's go down to our very handsome, illegitimate naman noon. Legitimate bachelor of the town, no? Also a named partner of the NBSB Law Associates Offices, or the Nartiga Boho Santo Niño Violon Law Offices in Valencia City. He is a graduate of University of San Carlos and also an alumnus of Bukidnon State University in his Juris Doctor. Also a best bar ever passer and a law professor at Bukidnon State University College of Law. Please help me welcome Attorney Von Derek Santo Niño, REB. A round of applause, please.
Good afternoon, everyone. Thank you, Attorney James, for this opportunity to share our knowledge to aspiring law enforcers and future public officials. I will be discussing the rules of evidence. But first, I would like to thank Attorney Yula because I myself has been subjected to different kinds of harassment. I've been called many names. Guapo, guapohon, pretty. Okay. Allow me to share my screen. Attorney James.
Yes, you're a co-host now, Attorney. You can share it now. Pero Attorney, makita mong notes.
Okay. Wait. Kindly Wait.
If you want, you can also follow what Attorney Boho did. Ipin na lang taka or what?
What?
Ipin na lang taka.
Pin?
Okay.
Present your feedback. Okay. Got it. I'll be discussing the rules of evidence. Rule 128 to 133. Why do we need to study the rules of evidence? First, it is important because you have to prove it in court. It is very easy to allege your claims and complain, but it is another thing to prove it. So the court has set the means to prove your claim based on a judicial proceedings. So rule number 128, section 1, evidence defined. Evidence is the means sanctioned by the rules of ascertaining in a judicial proceeding the truth respecting of the matter. The scope of these rules shall be the same in all courts and in all trials and hearings, except as otherwise provided by the law or other rules. The admissibility of evidence. Evidence is admissible when it is relevant to the issue and not excluded by the Constitution, the law, or rules. The evidence is relevant, must have such a relation to the fact in issue as to induce the belief in its existence or non-existence. Evidence on collateral matters shall not be allowed, except when it intends to any reasonable degree to establish the probability or improbable fact in issue. So, what need not be proved? Judicial notice when mandatory. So the rules enumerated that this will not be proven anymore in judicial proceedings: the existence and territorial extent of states, their political history, forms of government and symbols of nationality, the law of nations, the admiralty and maritime courts of the world and their seals, the political constitution and history of the Philippines, the official acts of the legislative, executive, and judicial departments of the national government of the Philippines, the law of nature, the measure of time, and geographical divisions. So these items, the litigants will no longer have to present evidence to prove this because these are already established facts. When is judicial notice discretionary? Public knowledge, capable of unquestionable demonstration, or things the judge should know based on their judicial functions. So public knowledge. So unsa man ang mga public knowledge kana mga chismis pwede. Katulad kanot lang gyud pangingon ganina sa kuha nga unsa nga mga forms of harassment sa ako ila ignon nga pretty or unsa. So public knowledge na siya, pwede na siya dili na i-prove sa judge or sa court. Judicial notice when hearing is necessary. During pre-trial and the trial, the court may motu proprio or upon motion shall hear the parties on the propriety of taking judicial notice of any matter. Meaning, sa trial or pre-trial, mag-conduct og hearing ang judge kung mag-judicial notice siya, whether in its own initiative or upon motion of the party, either parties. Before judgment or on appeal, the court may motu proprio or upon motion may take judicial notice of any matter and shall hear the parties thereon if such matter is decisive in a material issue in the case. Judicial admissions. An admission oral or written made by the party in course of the proceedings in the same case does not require proof. So if ang party submitted mga certifications, so mga evidences, so dili na siya i-prove, no need to prove it. I-prove pa gyapon. Does not require proof lagi, okay, ingon siya nga kuan kaning siya naman mismo nag-admit nga kuan nga sa fact nga iyang gi-submit. So ang other party unless iyang i-question or iyang i-contest, so ayaw siya mag-prove og kuan proof. Pero kung same ra iyang gusto pod nga i-introduce nga facts, so no need na to present evidence. The admission may be contradicted only by showing that it was made through palpable mistake or that the imputed admission was not in fact made. Rules of admissibility. There are three type of evidences: the object or real evidence, the documentary evidence, and the testimonial evidence. What is object evidence? Object evidence. Objects as to evidence are those addressed to the senses of the court. When object is relevant to the fact in issue, it may be exhibited to and examined or viewed by the court. So, senses to the court. So, sa eyes sa court, sa hearing, sa pwede po smell. So, tanan nga object nga ma-address to the senses of the court, muna mga object evidences, mga actual evidence, gina siya, real. Next is the documentary evidence. Documentary evidences are writings, recordings, photographs, or any material which relates to the letters, words, sounds, numbers, figures, symbols, their equivalent, or other modes of written expression. Photographs include still pictures, drawings, stored images, X-ray films, motion pictures, or videos. There are four types of evidences: the original document, the secondary evidence, parole evidence, and interpretation of documents. Original document is the document itself or any counterpart intended to have the same effect by a person executing or issuing it. So ang original gid mismo, the thing itself, wala na lain. The photographs includes the negative or any print thereof. If the data is stored in a computer or similar device, any printout or other output readable by sight or other means shown to reflect the data accurately is an original. Duplicates. A duplicate is the counterpart produced by the same impression as the original or from the same matrix or by means of photography, including enlargement or miniatures, or by mechanical or electronic recording, or by chemical reproduction, or by other equivalent techniques which accurately reproduce the original. So, kanang isang pala ni kanang photocopy machine, kuan na po siya, considered siya as duplicate. Or kanang sa carbonized nga copy document. Are duplicates admissible in evidence? Yes, a duplicate is admissible in evidence to the same extent as the original, unless a genuine question is raised to the authenticity of the original, or in the circumstance it is unjust or inequitable to admit the duplicate in lieu of the original. So, if ang content mismo ang the documents authenticity ang gina-question, so dapat gid i-produce in court ang original. Pero if not, pwede na ang duplicate. Then ito, if unjust ra pod kayo or inequitable, luoy ang PICAS party if dili i-accept ang evidence, so the court may allow the duplicate to be presented. What are secondary evidences? When original document is unavailable, the original document has been lost or destroyed, it cannot be reproduced in court. The offerer, upon proof of its execution or existence and the cause of its unavailability, without bad faith on his part, may prove its content by a copy or by recital of its contents in some authentic document or by testimony of witnesses in the order stated. When the original is nasa adverse party, under the control of the adverse party, he or she must have the reasonable notice to produce it. If after such notice and after satisfactory proof of its existence, he fails to produce the document, the secondary evidence may be presented as in the case of its loss. So nasa adverse party, and sometimes ang adverse party, para dili ma-prove ang claim sa PICAS party, so withhold niya ang evidence or ang document kay para dili ma-prove sa PICAS party. So the court may accept secondary evidences. Summaries. Section 7, summaries. When the contents of documents, records, photographs, or numerous accounts are voluminous and cannot be examined in court without great loss of time, and the facts to be established is only the general result of the whole, and contents of such evidence may be presented in the form of a chart or summary calculation. So meaning, ang example ka ng mga sales invoice, voluminous kayo, daghan kayo, pila ka tabs. So, pwede ra mag-present ang party o mga summaries, chart, unsa pa mga unsa na kanang sa summary, mga tally sheet or unsa ba. Section 8, evidence admissible when original document is a public record. When the original of a document is the custody of a public officer or is recorded in a public office, its contents may be proved by a certified copy issued by the public officer in custody thereof. Ang mga example ani, grabe ang kuan is ang kaning sa PSA, Philippine Statistics Authority, kaning atong mga birth certificates, mga marriage contract, marriage certificates sa sinumar. Anak, ang custodiana is naman sa PSA, so mangay lang ka dito og kuan, you will ask a copy from the PSA. For each copy, then kana siya nga mga evidence is admissible sa court. Then section 9, party who calls for a document not bound to offer it. So example, nagpresent ka og evidence or document dawaton sa court, but in the end basta mga document manggod sa in a court proceedings, after nimo na i-present, imo pa na siya i-offer sa court to be part of the evidence. The offerer dili siya compulsory nga iyang i-offer it as part of the evidence. Pwede niya i-exclude or dili niya i-present or i-offer as evidence. Evidence of written agreements, parole evidence rule. So evidence of written agreements. When terms of an agreement has been reduced in writing, it is considered as containing all the terms agreed upon, and there can be, as between parties and their successors in interest, no evidence of such terms other than the contents of the written agreement. So sa ganang mga contracts, so contract between two parties or pila ka parties, basta nag-execute sila og written agreement, written contract, so just considered na nag-contain tanan all terms agreed upon, then binding siya sa between the parties na nag-sign ana. Then dili na necessary nga mag-produce pa og other documents to prove sa ilahang agreement. However, a party may present evidence to modify, explain, or to add the terms of the written agreement if he or she puts in issue a verified pleading, the intrinsic ambiguity, mistake, or imperfection of the written agreement, failure of the written agreement to express the true intent and agreement of the parties. So, intrinsic ambiguity, mistake, imperfection. One, nasayop lang, wala kasabot. Or ang mga words dili kayo understandable, or ang mga technical terms. So dapat i-clear sa. Then second is kaning failure of the written agreement to express the true intent and agreement of the parties. Kanang dili dito, example anak is dili dito siya absolute sale. Ang intention ng tanto is contract to sell. Naman ay difference. So ang nabutang is absolute sale. So failure of the written agreement to express. So dapat siya i-modify. The validity of the written agreement. Third, so one, kaning valid ba ang agreement nila? Dili ba siya contrary to law or di ba siya bawal? Contrary to bawal mo naman din. Then the existence of other terms agreed by the parties or their successors in interest. Kaning nailain nga agreement, na supplemental or na kanang other document nga mo-prove pa nga lahi ilang sabot gyud or napay other nga agreement. Kani siya nga section, the term agreement includes wills. Wills nga dili ligid ha. Mga testamentary wills na. Interpretation of documents. So, basa-basahan na lang nato ni. Okay, lista-lista naman eh. Interpretation of writing of according to its legal meaning. So, unsay legal nga meaning sa mga words or kuan. Karong dili illegal. Then instrument construed as to give effect to all provisions. So, kung may mga pag apply sa each provision lugar, kaning pwede nimo siya ang pilion nga pag-construe or pag-understand sa instrument kay katong tanan provisions kay mo mahatagan og meaning, dili kay katong mo siyang i-independent kanil sa section 2, section 3 lahi nimo siya kung buntang ka lang na ay conflict sa mga meaning or other understanding, other interpretation. So pag-interpret sa mga provisions dapat katong i-kuan siya nga as to give effect to all the provisions. Then section 13, interpretation according to intention, general and particular provisions. So general and particular, kung general ang first nga or prior section, general ang iyang pagkakuan sa words, then sa next is na particular, then murag contradicting ang provisions, so mas mo prevail ang dapat ang particular. Interpretation according to circumstance, sama na ang basahon. For the proper construction of an instrument, the circumstances under which it was made, including the situation of the subject thereof and of the parties to it, may be shown, so that the judge may be placed in the positions of those language he or she so interpret. So example, kuan kaning nag-enter mo contract, then inyo ko ang katong kwan is kaslonon. So nag-enter mo contract nga maghimo siya og gown. So ang interpretation adto katong dapat katong na magini date ang kasal siguro, wedding. So dapat ang ikuan na is more on na date ang kwan kung mahuman na ang kasal niyo panuman ang gown. So meaning katong provisions nila isang example nga wala gid sila nakasabot as to its delivery. Pero tungod kay na may date ang kasal, so kwan siya kaning understood siya nga dapat i-deliver gid mo before sa kasal, sa wedding date. Isod man pod magpakasal nga haya pa din pagka honeymoon ang gown. Section 15. Peculiar signification of terms. The terms of writing are presumed to have been used in their primary and general acceptation, but evidence is admissible to show that they have a local, technical, or otherwise peculiar signification, and were so used and understood a particular instance, in which case the agreement must be construed accordingly. So na mga local terms, mga dialect siguro, kung ang i-translate nimo into English is lahi. Di kay ko ka think of one example na kay English speaking mangud kay ko. Written words control printed. So kanang kwan siya kaning sa values. Example nakabutang dito is 200,000 ang amount in words. Dayon ang sa number lang is nakabutang is 2,000. So gidungagan nila kay bali or bali day 2,000 lang ang sa words, ang sa katong gisulat nga numeric is 200,000. So more or less gidungagan og pila ka zero. So mo prevail ang written words. Experts and interpreters to be used in explaining certain writings. So mana. Then of two constructions which are preferred. When the terms of an agreement have been intended in a different sense by the different parties to it, that sense is to prevail against the either party in which he or she is supposed to, the other understood it, and when the different construction is a provision are otherwise equally proper, that is to be taken in which the most favorable to the party in whose favor the provision was made. Interpretation, construction in favor of natural right. When instrument is equally susceptible of two interpretations, one in favor of natural right and the other against it, the one in favor of natural right will prevail. The interpretation according to usage. An instrument may be construed according to its usage in order to determine its true character. The testimonial evidence. Who are qualified to be a witness? Section 21 provides that all persons who can perceive and perceiving can make known their perception to others may be a witness. Religious or political belief, interest in the outcome of the case, or conviction of a crime, unless otherwise provided by law, shall not be a ground for disqualification. So, ang palani is all persons who can perceive, perceiving, and can make known their perception to others. Muna siya ang qualification sa witnesses. Then, sa older version or sa previous rule, na disqualification by reason of mental incapacity or immaturity. So wala na siya gidelete kay kuan naman gyud time gyud nga bisan pa og mental incapacity or na immature ang tao, basta kay you can perceive, you are perceiving and can make known your perception to others. So qualified ka to be a witness. Section 22, testimony confined to personal knowledge. So a witness can only testify to those facts which he or she knows of his personal knowledge. Marakibali dili chismis. Disqualification by reason of marriage. During their marriage, the husband or wife cannot testify against the other without consent of the affected spouse. Exception. In a civil case, filed by the one against the other, or in a criminal case of a crime committed by one against the other, or the latter's direct ascendants or ascendants. Criminal case, ikuan ninyo ang criminal case or ang civil case. Kung civil case, sa kwan lang, against the spouse lang. Kung criminal case, kay against the spouse or yung anak or parents. Pwede. Disqualification by reason of privileged communication. The husband or the wife during their or after their marriage cannot be examined without the consent of the other as to communication received in confidence by one from the other during the marriage, except in civil case, katugyapan ganina, filed by the other on a criminal case. An attorney or person reasonably believed to be a client by a client to be a licensed or engaged in a practice of law cannot, without consent of the client, be examined as to any communication made by the client to him or her, or his or her advice given thereon. So exception lang sa attorney na pwede siya mo testify without the consent of the client na furtherance of a crime or fraud. Claimants to the same deceased client, then breach of duty by lawyer or client, then document attested by the lawyer, then joint clients. Wala na ang exception nga pwede mo testify ang attorney without the consent of his client. Then disqualification by reason of privileged communication. Physician, doctor, or a physician, psychotherapist, or person reasonably believed by the patient to be authorized to practice medicine or psychotherapy cannot, in a civil case without the consent of patient, be examined as to any confidential communication made for the purpose of diagnosis or treatment of patients' physical, mental, emotional condition. Ano man sa may reason ani para ang patient mag-honest gyud siya sa iyang doktor. Dili siya magtago-tago. So para ang doktor pod makahatag pod og sakto nga medical advice or treatment. The term psychotherapist is a person licensed to practice medicine or a person licensed as a psychologist. Fourth, a minister, a priest, or a priest person reasonably believed to be so without the consent of affected person be examined as a communication or confession made to by any advice given to him or her. So labi na sa Catholics no ga namatay murag confession nato sa mga priest. So katong communication kon siya confidential. Di po siya magamit as evidence sa court. Then a public officer. A public officer cannot be examined during or after his or her tenure as a communications made to him or her in the official confidence when the court finds that the public interest would suffer by the disclosure. So ang mga example na to is more or less makanang yung sa military siguro. Okay, kung maging mga state secret or kan mga ambassadors. So kana sila nga mga officers kuan gyud dili pwede. Then testimonial privilege, parental and filial privilege. No person shall be compelled to testify against his or her parents or direct descendants, child or other indirect descendants, except when such testimony is indispensable in a crime against that person or by the parent against the other. So ang mag-invoke ani is ang example ang child dili siya pwede sa kuan mag-compel to siya pwede ma-compel to witness against his parents or her parents. Pero si child dapat ang mag-invoke, dili pwede ang katong ganang mo guilty kay bali nga party. Privilege relating to trade secrets. A privilege, a person cannot be compelled to testify about any trade secrets. Kana mga secret recipes. Or sa pananaw ng mga future plans nila, future endeavors, future investments nila sila pwede. Admissions and confessions. Admission of a party. The offer of compromise not admissible. Admissions of a party, the act of declaration or omission of a party as to relevant fact may be given in evidence against him. So kung ikaw nag-admit ka nga, example kaning one ka partner ka sa partnership, although technically dili or kanang really in reality dili gyud, but nay nag person nga nag-believe sa imong declaration. So liable na ka sa party as a partner sa adto nga party nga nag-believe or nag-rely ato nga information nga imong gihatag sa ila. Admission by third party. The rights of a party cannot be prejudiced by an act, declaration, or omission of another, except as herein provided. So, kung nag-admit nga third party, example, ingon siya nga uyab siya aning usa, nga nani uyab, so katong uyab nga tinuod, or katong lalaki nga ilang gikuanan, ingon siya nga, uy, dili ko pwede ma-prejudice sa declaration sa other sa third party. So dili i-prove pa diyan ninyo sa court kung mag third party mo. Admission by section 30, admission by a co-partner or agent. The act or declaration of a partner or agent authorized by the party to make statement concerning the subject or within the scope of his or her authority during the existence of partnership or agency may be given in evidence. Basta kay authorized lang gid ka within sa iyong authority nag-aka. So magamit siya against the other party or other partner. Admission by the conspirator. The act or declaration of a conspirator in furtherance of conspiracy and during its existence may be given in evidence against the co-conspirator. Pero kwan lang siya, kaning kwan na keyword ani is in furtherance of the conspiracy and during its existence. So kung other than that, dili na dayon siya applicable or admitted sa katong iyang co-conspirator. Admission by previous, section 32. Where one derives title to property from another, the latter's act, declaration, or omission in relation to the property is evidence against the former if done while the latter is holding the title. So kaning mga tenant or tenancy relationship. So kung nag-rent ka diha or leaser or leasee, nag-lease lang ka diha, gabang ka, so di ka nga owner na rin ka. Admission by silence. Excuse me. Admission by silence, an act or declaration made in the presence and with the hearing observation of a party who does not or say nothing when the act or declaration is such as to naturally to call for action or comment if not true, and when proper and possible for him to do so may be given in evidence against him. So kung giingon ka nga sa man o pwede examplean ni nga example tagiya ka sa or dili siya partner, then nag-engage siya o business, then giingon nga partner mo siya, then ikaw pwede ka nga mag-deny or imong ignon nga no, dili ta partner. So kung in your silence wala ka nagtingog or wala nimo gi-contradict iyang claim, so admission by silence siya. So na ka kaning liable ka in case na breaches or na mga damages to be filed soon. Confession. Confession, the declaration of an accused acknowledging his or her guilt of the offense charged or any offenses necessarily included therein may be given in evidence against him. So ayaw gid og confess kung wala gi-charge mo na nga sa criminal case, dapat ang information must contain kanang specific yun nga allegation or sa nga crime ang ihang na-commit. kay para ang defense or ang accused maka-defend siya sa katulad pod nga action. Pero kuan kaning in the course of his defense ni admit siya nga bis nga ang charge sa iya is kuan lang, damage lang kay na kay na sangiran niya in the course of his defense nakaingon siya nga na damage to niya kay nidagan siya kay na siya kuan kaning na siya kawat or unsa. So wala ta to sa iyang charge pero kay kuan man iya magiangkon, so magamit to sa iya mapriso siya. Previous conduct as evidence. Similar acts, section 35. Similar acts evidence that one did or did not do a certain thing at one time is not admissible to prove. Or she did not or did not do the same or similar thing at the moment time, at another time. But it may be received to prove a specific intent or knowledge, identity, plan, or system. So kaning one kibali ani is ilang ingon nga kaming mga honest once a cheater daw always a cheater. So dili siya pwede. Unless lang is panagid kaning repetitive. So pwede na magamit sa iya kay kanang panagid kaning murag systematic na or habit, custom, scheme na gid niya. So pwede ra pod siya. Pero dili gid siya general rule kibali. Kanang once a cheater always a cheater ana. Section 36, unaccepted offer. Wait sa klasa. Okay. So magkuan ako napasanan ako ni. Okay, 36 section 36, testimony generally confined to personal knowledge. Hearsay excluded. Hearsay is a statement other than the one made by the declarant while testifying at a trial court or hearing. So chismis again offered to prove the truth of the facts asserted therein. So, as a general rule, hearsay evidence is inadmissible. So dili gid siya admissible. Exceptions, dying declaration, statement of decedent or a person of unsound mind, declaration against interest, act or declaration about pedigree, family reputation or tradition regarding pedigree, common reputation, part of res gestae. Then records of regular conduct and conduct business activity. Exceptions. Continuation, entries in official records, commercial list, and the like, learned treatise, testimony, or deposition of a former proceeding. Opinion rule. General rule, the opinion of a witness is not admissible except expert witness, opinion of an expert witness. Then, ang ordinary witness, pwede ra pod admit provided nga kanang identity of the person lang, then handwriting which siya sufficient familiarity and mental sanity of a person whom he or she is sufficiently acquainted. So kaila gid niya. Character evidence not generally admissible. Exceptions, in criminal case, the character of the offended party may be proved if it tends to establish the reasonable degree. In civil case, evidence of moral character of a party in a civil case is admissible only when pertinent to the issue of the character involved in the case. Evidence of good character in criminal and civil case, not admissible until such character has been impeached. Burden of proof, burden of evidence and presumptions. Burden of proof or evidence is the duty of the party to present evidence on facts in issue necessary to establish his or her claim or defense by amount of evidence required by law. Burden of proof never shifts. The burden of evidence, muna ni mag-present na mag-evidence ninyo. Ay, na-difference sa class ha? Burden of proof or burden of evidence. It's the duty of the party to present evidence to sufficiently and establish or rebut the fact in issue to establish a prima facie case. Conclusive, section 2, conclusive presumptions. Mga tanong yun ganina. When letter B, the tenant is not permitted to deny the title of his or her landlord at the time of the commencement of the relation of the landlord and the tenant between them. So kung nag-tenant lagi ka diya, di ka pwede nga ma-owner na ka. Disputable presumption. So daghan kay ni. So just check the rules. No presumption of legitimacy or illegitimacy. Kani siya sa anak ni. There is no presumption of legitimacy or illegitimacy of a child born after 300 days following the dissolution of marriage or the separation of spouses. Whoever alleges the legitimacy or illegitimacy must prove such allegation. Presumptions in civil actions and proceedings. All civil actions and proceedings not otherwise provided for by law or these rules. A presumption imposes the party of whom directed the burden of going forward with evidence to rebut and meet the presumption. If presumptions are inconsistent, the presumption that is founded upon the weightier considerations of policy shall apply. If considerations of policy are equal or weight, neither presumption applies. Presentation of evidence. Examination of witness. Examination of witness to be done in open court. Proceedings to be recorded. Rights and obligations of a witness. A witness to be protected from irrelevant, improper, or insulting questions and harsh, insulting demeanor. Must be respectful dapat ang counsel if ever nga mag-cross-examine siya. Then, not to be detained longer than the interest of justice require. Not to be examined except only as to the matters pertinent to the issue. Then, not give an answer which will tend to subject him or her to a penalty for an offense unless otherwise provided by law. And not to give an answer which will tend to degrade his reputation. But a witness must answer to the fact of his previous or final conviction of an offense. Order of examination in the court. So, direct examination by the proponent. Sa karon nga rules is na naman tayo judicial affidavit. So, prepared dadaan ang mula kibali direct testimony sa witness. So, i-present lang siya sa court, i-identify, then subject na siya sa cross-examination. Then, pag gusto i-correct ang PICAS counsel na redirect examination by the proponent. Then, recross examination by the opponent. Recalling of witness. Dapat ng witness ng tayo, dili na siya, kausala siya ipa-adjo sa court yun to be subjected to cross-examination. Pero, by both parties, after the examination of a witness by both sides, has been concluded, the witness cannot be recalled without leave of court. The court will grant or withhold the leave in its discretion as the interest of justice may require. So, kausala gid siya dapat ibutang sa witness stand. Unless magkuan ang court mag-allow. Leading and misleading questions. So, dapat ang no leading questions. General rule, leading and misleading questions are not allowed. Exceptions during cross-examination, preliminary matters, or when there is difficulty in getting the direct or intelligible answers from the witness who is ignorant, a child of tender years, or feeble mind, or deaf and mute. So, ang cross-examination, pwede siya mag-leading questions. Then, kuan lang dayon sa katong mga bata nga kailangan gid siguro di kay kasabot or di kayo lisod kayo maghatag og kuan answer. So, kuan na lang sa ang pagmanner sa paghimo sa question is kuan na lang mo answerable by yes or no. Muli na ang kuan class ang kanang leading question. Unwilling hostile witness of a witness who is of adverse party or an officer, director, or managing agent of a public or private corporation or a partnership or association which the adverse party. Okay, what is a misleading question? A misleading question is one which assumes a true fact not yet testified to or by the witness or contrary to which he or she is previously stated. It is not allowed. So wala pa galit niyo na discuss dia ingnon na nimo nga ang PICAS Council yan ang ingnon nga di ba o kanang i-prove na ba nakita man nimo bis nga mo na subject sa kuan. Bisag wala pa gi-admit yan ang isulti. Nga di ba nag-date man mo wala pa mo nag-date yun. Okay. Impeachment of adverse parties witness. So let's go over lang ani. Kamo lang din mag-over lang mo ani. Then mag-chat lang mo unsa na may question sana. Authentication and proof of documents. Classes of documents there are two, public and private document. Public documents are written official acts or records of sovereign authority, official bodies and tribunals, and public officers, whether of the Philippines or a foreign country. Second, document acknowledged before a notary public, except last will and testaments. Kaya kaning last will testaments last kay private ni siya. Sekreto ni siya. Documents that are considered public documents are under treaties, conventions which are enforced between the Philippines and other country or source. Sa akin nagkuan si ang next speaker gusto na mag-start ang next speaker. Public records kept in the Philippines of private documents required by law to be entered therein. Then proof of private documents, its due execution and authenticity must be proved by anyone who saw the document executed, by evidence and genuineness of the signature of and handwriting of the maker, or by evidence by showing its due execution. So muna siya ang class kung public document, mas dali lang i-present lang nimo. Pero kung private document siya, daghan pa ka i-prove nga nakita nimo pagkuan or magkita pa kag witness kinsa nagkuan ana, kinsa nag-prepare din ang signature mo bag yun. When evidence of the authenticity of private document not necessary, kani exception sa kuan private document basta the ancient document rule, when a private document is more than 30 years old, is produced from a custody in which would naturally be found genuine and unblemished by any alterations or circumstances of suspicion, no other evidence of its authenticity need be given. Harap sana karaan na kayo nga kuan nga document. Dili na siya kung private document. Na how genuineness of handwriting be proved. Magmin mo na og kuan kana mga expert. Public document as evidence. Section 24, proof of official record. Ano ko nag-notes ani? Offer and objection. Offer of evidence. Ito sa the offer of the testimony of a witness in evidence must be made at the time of the witness is called to testify. The offer of documentary evidence and object evidence shall be made after the presentation of the party's testimonial evidence. Objection. Objection to offer of evidence must be made orally immediately after the offer is made. Objection to testimony of a witness for lack of formal offer must be made as soon as the witness begins to testify. Objection to question propounded in the course of the oral examination of the witness must be made as soon as the ground therefore become reasonably apparent. Ang mga pananikas, mga technical na kayo siya sa court proceedings, dapat paspas. Bisag ang kuan ni mga karaan na gid nga mga lawyers ani. May mga maayo kaning mga baguhan di pa kayo ka kung say maulo pagalig mag-object. Pero dapat kung nakita gid nimo nga objectionable gid, object gid mo. When repetition of objection unnecessary. When it becomes reasonably apparent in the course of the examination of a witness that the questions being propounded are the same class as those to which objection has been made, whether such objection was sustained or overruled, it shall not be necessary to repeat the objection. being sufficient to adverse party to record his or her continuing objection as to such class of question. So dili ka pwede maging object. Kung tanaw nimo nga balik-balik na or same lang nga line of questioning, so imo na lang i-state for the record nga imong continuing objection. Ruling, the ruling sa mga objection. The ruling of the court must be given immediately after the objection is made, unless the court desires to make a reasonable time to inform itself of the question presented. So pag object sa PICAS counsel, dapat ang court mo rule whether to sustain or opposite sa sustain? Class, yes, striking out of an answer. Section 39. Should a witness answer the question? Should a witness answer the question before the adverse party had the opportunity to voice fully its objection to the same, or where the question is not objectionable, but the answer is not responsive, or where a witness testifies without a question being posed or testifies beyond limits set by the court, when the witness does a narration instead of answering the question, and such objection is found to be meritorious, the court shall sustain the objection and order such answer, testimony or narration to be stricken out. So off the record na rin to siya, di chapel sa case. Section 40, tender of excluded evidence. Importante ka po ni. If documents or things offered in evidence are excluded by the court, the offeror may same attached to or made the part of the record. If the evidence excluded is oral, the offeror may state for the record the name and the other personal circumstances of the witness and substance of the proposed testimony. Ang use ani class is kanang, although excluded siya sa evidence, pero pag mapildi mo usahay, mag-appeal mo, so para ma-appeal siya sa record, so inyong i-tender of excluded evidence. Weight and sufficiency of evidence. Kamay na lang kayo, Attorney Eurico. In civil cases, preponderance of evidence. In criminal cases, proof beyond reasonable doubt. And in administrative cases, substantial evidence will suffice. Extrajudicial confession, not sufficient ground for conviction. So check na lang mo sa Rule 133. Wait to be given opinion of an expert witness. So court ra bahala. Discretion gyapon sa court bisag expert witness. Siya gyapon ang bahala nga hatag og kaning discretionary gyapon sa court kung i-take ba niya or not ang opinion sa expert witness. The power of the court to stop further evidence. Then evidence on motion. Last na ni. Evidence on motion. When a motion is based on facts not appearing on the record, the court may hear the matter on affidavits or depositions presented by the respective parties. But the court may direct that matter to be heard wholly or partly in oral testimony or depositions. Okay. Thank you.
Okay, thank you very much, Attorney Von, for that very lengthy yet very comprehensive discussion on evidence. So yes, we totally understand nga ang subject nga evidence is quite technical, and lisod kayo siya i-teach in such a way nga mag-grasp dayon. So that is why I always tell my students to really read the book and then read annotated books so they will be able to understand also discussions. So unlike in law schools we are required to read cases sa criminology and other courses, primarily sa criminology, they are not encouraged to read cases. Only a few students have the initiative to really read the cases. So that is why thank you kayo, Attorney Von, for that discussion. So kung buhi pa tanan and alive pa diri sa Zoom o sa YouTube, you type Pogi si Sir Von or si Attorney Von. Kay murag mo magid na ang unsa mura og saya pang giingon there's no need for further production of evidence sa iyang kagwapo kay given na siya. Wala na judicial notice anak. Okay, so both our Zoom and our YouTube are being flooded by comments like Pogi si Attorney Von. So very good no kay buhi pa. It means nga ga-respond pa ang atoang o ga-respond pa ato ang mga viewers. They are still alive and kicking and very excited to meet our last but definitely not the least speaker who will be speaking on criminal procedure and court testimony. So she is a graduate of Bachelor of Secondary Education, major in English cum laude at Central Mindanao University, and also an alumna of Bukidnon State University College of Law with a degree Juris Doctor. And she is currently employed in the Philippine Mediation Center under the Supreme Court, and she's also teaching evidence and other law subjects with criminology students in the different schools here in Bukidnon. Ladies and gentlemen, it is my pride and honor to present to you our next lecturer for the last topic, which is criminal procedure and court testimony, Attorney January Ann Lorico. A round of applause, please.
Thank you so much for that very nice and generous introduction, Attorney James. I think I need to stop my video because I'm so sorry. My connection is not really good this afternoon, but hopefully I can deliver to you the topic assigned to me by your very brilliant, one of the most competitive and excellent lawyers in our time, Attorney James Vilon. To the equally brilliant, I second the motion. To the adjective young, promising, beautiful, and handsome colleagues in the legal profession, Attorney Boho, Attorney Diana, Attorney Santo Niño of NBSV, Attorney Gascon, thank you so much. It's so nice to see you this afternoon, and thank you for refreshing our minds with the topics that you have presented. So I hope wala pa nangatulog ang imuhang mga estudyante, Attorney James. Kung
ay wala pa na, ma'am, kay grabe gid ang ilang pagkapi anak, ma'am, kay nakasalalay pa gid ang future sa ato mga future criminologists. So birada, madam.
Yes, thank you so much, future law enforcement officers. Do you know that real heroes don't wear capes? Real superheroes wear uniforms and badges, and you are members of military, the law enforcement, and the first responders. So you are our real superheroes. So I hope you do well in your college, in your undergraduate courses, because what you will be learning in your degree will actually really help you when you become an enforcement officers. So this afternoon, I'm tasked to discuss criminal procedure and court testimony. This is actually a one-sem subject, but I don't know. Gusto ata sa inyong teacher nga i-digest siya in less than 20 minutes. But I know that he believed in you nga makaya ra gid ninyo, so we will do this, okay? Criminal procedure and court testimony. So these are the topics actually daghan kaayo no kanin ninyo. But I hope your teacher will be giving you this PowerPoint presentation para masadihan ra sad ninyo in your free time. So mo na siya ang topic, scope sa criminal procedure. We have arrest, searches and seizures, prosecution of criminal action. We have preliminary investigation, inquest proceeding, criminal jurisdiction and venue, bail, motion to quash, arraignment and plea, right of the accused, pre-trial, trial, court testimony, and we also have judgment and other post-judgment remedies. So daghan kaayo. Actually, kining mga topics dapat lahi na siya nga day i-discuss, but we'll just have a bird's eye view of these topics, as we start our lesson for this afternoon. So our Constitution emphatically provides that no person shall be deprived of liberty without due process of law, and no warrant of arrest shall be issued except upon probable cause to be determined personally by the judge. This is provided under sections 1 and 2, okay, of Article 3 of the 1987 Constitution. Okay, so we have here a problem. Okay, the problem says Crisostomo was killed by Damaso during a fight over a hostess in a nightclub. 2 days after the incident, and upon complaint of the widow of Crisostomo, the police arrested Damaso without a warrant of arrest and searched his house without a search warrant. The question, is the arrest of Damaso legal? Okay, so we will learn the answer later on as we continue with the discussion. Okay, so we are talking actually about arrest. Okay, this is actually the start. Why should there be criminal procedure? Because there are people deprived of liberty, and one way to deprive a person, okay, of his or her liberty is by virtue of a warrant of arrest. So what is arrest? According to Sir James, siguro sa inyong mga klase, nag-discuss na siya the taking of a person into custody in order that he may be bound to answer for the commission of an offense. Okay, an actual restraint of a person to be arrested or by his submission to the custody of the person making the arrest is actually found in sections 1 and 2 of Rule 113 of the revised rules of criminal procedure. Okay, so what's the concept and nature of arrest? Okay, so general rule, to effect a lawful arrest, there must be a valid warrant of arrest. Unsa man ni siyang valid warrant of arrest? Okay, it must be issued by the judge upon filing by the public prosecutor of an information in court, presupposing that the public prosecutor found probable cause to bring the respondent to trial after the conduct of preliminary investigation. I'm sure na-discuss na sa inyong teacher unsay preliminary investigation. Exception to the rule of a valid warrant of arrest is warrantless arrest. We will learn that one later on. So, muna na siya, ang execution of a warrant, mag-sign si judge, na-determine niya nga na probable cause, enforce ang warrant of arrest sa law enforcement officers, that will be you in the near future, within 10 days from its receipt. And within 10 days, after the expiration of the period, ang officer mag-make siya report sa judge na nag-issue sa warrant. Kung wala niya nakita ang tao, dapat state niya ang say reason ganong wala niya nakita or na-execute ang warrant of arrest. Okay, so an arrest be made on any day and at any time of the day or night. So when making an arrest by virtue of a warrant, the officer shall inform the person to be arrested of the cause of the arrest and the fact that a warrant has been issued for his arrest, except kung dagan ang arrestuhon. Okay, when he flees or forcibly resists before the officer has opportunity to so inform him. Okay, imbis nga magyaw-yaw siya, dakpo na lang gid niya, no? Okay, para madakpan gid niya. When the giving of such information will imperil the arrest. Okay, so kung dagan na di ito siya, gatakas na siya, pwede na nga dili na niya ikuan, you are being arrested by virtue of, okay, dili na siya magyaw-yaw ana. Okay, diretso na niya dakpon ang gaarestuhon. Okay, atong naka-name sa warrant of arrest. So, if not a valid warrant of arrest, na po tayo gitawag nga arrest without warrant. Kanus aman ni siya pwede mahimong valid. Okay? So, general rule, valid warrant of arrest. Kung walay warrant of arrest, unsa mga instances nga pwede makadakop, okay, ang police officer or any private person, okay, sa usa ka tao. Okay? So, without a warrant, a person may be arrested when, okay, in these 3 instances only. So, we have in flagrante delicto, hot pursuit, and the last one is re-arrest of escaped prisoners or escapees. Okay, so a valid arrest may lead to valid search or seizure, given nga naagad ang kining nga instances, kining tulo, in flagrante delicto, hot pursuit, and re-arrest of escaped prisoners. I think your teacher already discussed this to you, okay, during the SEM, okay, during the SEM, okay, this SEM. So let's just have a short refresher of what is in flagrante delicto under section 5A of Rule 113. So for an in flagrante delicto arrest, under paragraph A to be valid, the following elements must be present. First, the person to be arrested must execute an overt act indicating that he or she just committed, kanang bago ginatapos, is actually committing kanang kamulo ginadibuhat ang ang crime, or is attempting to commit a crime. Muna siya in flagrante delicto. What else? Such overt act is done in the presence or within the view of the arresting officer. Pinaka-importante ni siya. Okay, kay dili na siya matawa nga flagrante delicto kung wala ka diha. Dapat in the presence or within the view of the arresting officer. Next, hot pursuit. Hot pursuit. There are two elements to be present, that must be present. Okay, first, an offense has just been committed. Bago lang ginahitabo, okay? And the second one is the arresting officer has probable cause to believe, based on personal knowledge of facts or circumstances, that the person to be arrested has committed it. So, muna difference sa inflagrante o sa hot pursuit class, okay? Kaya ang sa inflagrante, dapat naa ka. Sa hot pursuit, ang imo karagyong panghawakan is probable cause to believe, based on personal knowledge. So, dili necessary nga naa ka sa hot pursuit of facts or circumstances, okay, that the person to be arrested has committed it. So say for an example, there's a person nga gidunggab, okay? So gipangita ninyo ang kinsay nagdunggab. Nakita nimo na tagbuan nimo si Juan nga nagkadugo-dugo nagdalag kutsilyo, okay? So probable cause to believe based on personal knowledge of facts or circumstances, okay, that the person to be arrested has committed it. So consequently, inyong gi-arrest si Juan, kay siya may nagkadugo-dugo, siya may nagunit og kanang kutsilyo, unya ang crime nga nahitabo is dunggab man. So kung kuanto siya, lahito siya nga kanang crime, dili pwede ma-impute si Juan, no? Pero basin di ay nag-cosplay ra dito si Juan, okay? But then kung ang crime is ingato, na dunggaban or na gidunggab, okay? And then nakita niyo si Juan nga ang circumstances inyong kuanon na kay probable cause to believe, based on personal knowledge of facts or circumstances, that a person to be arrested has committed it. So that's hot pursuit. And then always remember that in cases falling under paragraphs A and B, katong inflagrante delicto of hot pursuit, the person arrested without a warrant shall be delivered to the nearest police station. Dili na doon sa balay ha, sa police station, for the conduct of inquest proceeding. Dili pwede ang preliminary investigation. We have this procedure called inquest proceeding. We will learn that one later on. Section 7 of Rule 112 of the Revised Rules of Criminal Procedure says, when a person is lawfully arrested without a warrant, okay, involving an offense which requires a preliminary investigation, since dili man siya by virtue of a valid warrant of arrest, an inquest by the public prosecutor will follow instead of a regular preliminary investigations. I hope that's clear. We also have the provisions from Article 125 of the Revised Penal Code that provides penalties against the public officer or employee who shall delay in the delivery of detained persons to the proper judicial authorities within a period of 12 hours, 18 hours, or 36, okay? So, kanang mga gipang dakop din ha, nga dili gani i-turn over properly sa judicial authorities, okay, more than sa hours prescribed, na sila, pwede silang mag-face of penalty under revised Article 125 of the RPC, depending on the gravity of the offense. So notwithstanding the waiver, the person arrested may apply for bail and the investigation must be terminated within 15 days from its inception. So, when siya warrantless arrest, when the person to be arrested is a prisoner, when siyang escapee, who has escaped from a penal establishment or place where he is serving final judgment, or is temporarily confined while his case is pending, or has escaped while being transferred from one confinement to another, pwede na siya dakpon. Okay, so mura na siyang mga instances, again, in flagrante delicto, hot pursuit, and rearrest of an arrested person or an escapee. So I hope, or escape prisoner. So I hope you will remember that one. Of course, when you arrest someone, okay, ang mga law enforcement officers, dapat memorize ninyo ha. Okay, importante gini siya. You should always remind those people, you should always say this, memorize this, familiarize this, the Miranda Doctrine, okay? Any person under custodial investigation has the right to remain silent. Oh, imo po siya ino nga, hindi na ka maghilom. Anything he says can and will be used against him in a court of law. So pati inform ginin niyo ang rights, ang akiyahang mga rights. And he has the right to talk to an attorney before being questioned and to have his counsel present when being questioned. And lastly, if he cannot afford an attorney, one will be provided before any questioning if he so desires. I think ang mas comprehensive na discussion ani was done with by your teacher already, so I will not be discussing more of this. So going back sa question, kung si Crisostomo gipatay niya sa Damaso during a fight over a hostess na nightclub kay gwapa kay ng hostess, 2 days after sa incident, complaint sa widow ni Crisostomo Ibarra, joke lang. The police arrested Damaso without a warrant of arrest and searched his house without a search warrant. So the question is, the arrest of Damaso legal? Alternative suggested answer says no. A warrantless arrest requires that the crime has in fact just been committed and the police arresting has personal knowledge of facts that the person to be arrested has committed it. So na-fall siya under supposedly sa hot pursuit. However, the crime here has not just been committed since a period of 2 days has already lapsed. So the police arresting has no such personal knowledge because he was not present when the incident happened. Okay, so that can just be a suggested answer. Anyway, so thank you. I think that's all for arrest. Now we will go to prosecution of criminal action. Kung akong sundon, akong sundon, ako na lang ihatag sa inyo. Muna dire na mag-end akong lesson. But anyway, so this is just the whole bird's eye view of how to prosecute a criminal action. So you have first, of course, to institute it. Okay? Mag-start jud ka, magsugod jud ka og file of complaint. A complaint. Okay, so a person charged of a crime before the prosecutor's office is called respondent. Okay, ang katong nag-charge, katong nag-complain, mo to siya gitawag nga complainant. Okay, so in accusing the crime, the complainant or the offended party, any peace officer or other public officer charged with the enforcement of the law, okay, is will be the one to institute the criminal action. So we will learn, okay, just look at the picture. I'm going to show you some of the slides I made regarding this bird's eye view. Okay, so first, filing the complaint with the prosecutor's office. So dalion na ako ni siya, I think I don't have enough time. Of course, okay, you have to file a complaint first. This is a sworn statement. Nga i-charge nimo si Juan, nga iya kang giunsa, okay? So before any peace officer, okay, a peace officer can do this, okay, offended party can do this, public officer charged with the enforcement of the law violated, okay, can file this complaint. So we have a complaint affidavit if there's one complainant, if daghan, joint complaint affidavit. So sa mga cases in adultery, concubinage, seduction, abduction, acts of lasciviousness, and libel class, only the offended party can institute the case. Okay, so remember that one. Nga dili pwede nga sa adultery ang imuhang sister-in-law ang mag-file ana. Sa concubinage, dili pwede nga imo igsoon. Dapat ikaw mismo, okay, or sa seduction or sa abduction ba, or acts of lasciviousness, katong gikisan-kisan ka, hindi ka ganahan gikisan ka, dapat ikaw mismo nga gikisan ang or gigakos-gakos against your will ang muadto dito sa prosecutor's office para mag-file. Dili pwede imong silingan. The same thing with libel. So kung kinsa tong gisiraan, mo to siya mismo ang muadtog yun. Okay, mora na siya mga cases nga dapat ang offended party can institute the case. Other cases, pwede si offended party, pwede si peace officer, pwede si other public officer charged. So I think your teacher already discussed with you kinsa na silang mga officer charged, okay? Like the public prosecutor. So in all criminal prosecutions, knowing the name of the accused, the name of the offended party, tanan ha, sa complaint dapat kabalo kag kinsa imuhang ginasumbong, the elements of the crime charge based on facts, the time, the place of the commission of the crime are all part of the ensuring the right of the accused to process and to be informed of the nature and cause of the accusation against the accused. It's very important. So, manini siya, name of the accused, name of the offended party, the commission of the offense, designation of the offense, and duplicity of offenses, and then the information. So an accusation in writing charging a person with an offense, subscribed by the prosecutor and filed with the court. So I have here an example. Okay, this is an example of an information. So the undersigned accuses blah, blah, blah of slight physical injuries under Article 266 of the RPC. okay, blah, blah, that on or about the 24th day of October in Quezon City, Philippines, the above name accused did then and there willfully, unlawfully, feloniously attack, assault, and employ personal violence upon the person of blah, blah. Okay, so example rin is ha, by then and there punching her in the right side of her neck, thereby inflicting upon her physical injuries, which will require medical attendance for a period of 1 to 9 days, under which incapacitate, okay, the said complainant. Okay, so slight physical injuries ra siya kay 1 to 9 days raman siya. Okay, kung more than that, okay, pwede siya less serious. Kung more than 30 days pag yun, okay, so pwede siya serious physical injuries. Then assignan siya sa prosecutor and must be approved by the chief prosecutor. Okay? So ang magbuhat sa information class dili ang complainant ha, ang prosecutor nga assigns a case, and then it must be approved by the chief prosecutor. So next, okay, so we talk about inquest ganiha, okay, and we also discuss about preliminary investigation, okay, but we'll just okay, a short discussion about preliminary investigation unsa gani ni siya. Section 3 rule 112 unsa may procedure. Okay, so first, mag-files of complaint. So make sure the complaint clearly and completely states the address of both parties, including the witnesses, okay? And then the number of copies will depend on the number of respondents plus the 2 copies for official file. So mga lawyers, may kayo ani. Si Attorney Santo Niño, the litigating lawyer of NBSB, may siya mag-submit o mag-file of copies. The complaint affidavits must be subscribed and sworn to before any prosecutor or government official authorized to administer oath. If there is no available prosecutor or government official authorized to administer oath, go to notary public. So the subscribing officer must certify that he or she personally examined the affiants and that he or she is satisfied that they voluntarily executed and understood their affidavits. Okay, so muna siya ang sa preliminary investigation. So ganini siyang preliminary investigation. Within 10 days from receipt of the complaint of the prosecutor, the prosecutor will either, okay, pagka-receive niya sa complaint sa complainant or sa offended party, either i-dismiss niya ang kaso, mag-issue sa subpoena, i-attach niya ang copy sa complaint affidavit together sa evidences. Okay, isyuhan niya sa subpoena ang respondent. Okay? Para ang respondent iyang i-examine ang evidences na gi-present, gi-submit sa offended party or sa complainant, okay? Or within 10 days from receipt of subpoena, ang respondent mag-submit o counter affidavit. Okay? Affidavit of the respondent's witnesses may also submit. So affidavits must be sworn in before the prosecutor or any other officers mentioned in the initial step. So pwede na yun nga i-dismiss no sa prosecutor, sa public prosecutor. Okay, pwede na po nga ipadayon niyang kaso, iyang tanawon sa mag-issue sa subpoena, tawagon niyang respondent kay para ma-determine kung naging probable cause that a crime has been committed. Okay? And third step, the prosecutor may conduct hearings to clarify some issues on the case. So, ipamit, kita na ganyan, tama ba gini siya? Ang parties during this hearing, actually, they are not given the right to interrogate. Mostly, prosecutor agad ang pwede makapangutana. But both parties may submit questions to the prosecutor for any questions to the other party. So, hearing shall be held within 10 days or upon expiration of the period to submit the counter affidavit. So, si complainant, file siya og complaint, mag-issue subpoena si prosecutor, mag-file po og counter affidavit si respondent, and then they will have the hearing. Okay, it shall be held within 10 days or upon expiration of the period to submit the counter affidavit. And lastly, if the prosecutor finds probable cause in the form of a mag-issue siya resolution, okay? Kung makitaan sa prosecutor nga na probable cause, mag-issue sa resolution. He or she shall issue a criminal information and a certification under Section 4 of Rule 112. So no need for such certification if the case is dismissed. Okay, kung i-dismiss niya, wala, no need na. Pero kung nakakita si fiscal of probable cause, okay, so na siya mag-issue resolution and then information iyahang i-file dito sa court. Dito na din magsugod ang pag-commence, okay, sa kaso. So I think that's all for preliminary investigation. Time check, it's 4:02. So I hope you can still stay with me. We will proceed to inquest proceedings. Dali na nako ni siya. So kato na siya kung without warrant, okay, pwede na dayon nga dinhi na dayon magamit ang inquest proceeding. So it is an informal and summary investigation conducted by the public prosecutor in criminal cases involving persons arrested and detained without the benefit of a warrant of arrest issued by the court. So I think na-discussan na ako ni siya. 12 hours for light offenses, 18 hours less grave offenses, 36 hours for grave offenses, and 14 days for violation of anti-terrorism law. Dili nimo pwede i-detain ang person sa light offenses more than 12 hours. Kung less grave offenses, dapat dili siya ma-detain more than 18 hours. Okay? Kung walay information nga masangat sa korte, i-release ang na-detain. Okay? 36 hours for grave offenses. Kung wala pa information masangat sa korte, okay, pwede na siya. I-release na ang katong gidetain. So, characteristics of an inquest, it is informal, summary, conducted by the public prosecutor, and covers only criminal cases. Dili pwede ang civil case have, very important na siya. So, manina siya ang difference sa preliminary investigation and inquest proceeding. Sa preliminary investigation, wala na arrest. Okay? Sa inquest na arrest ang katong accused, okay, or respondent. Okay, sa preliminary investigation, not detained. Sa inquest, already detained ang katong, okay, already detained si accused. Preliminary investigation, regular filing, nagsugod yun sa kanang complaint, okay? Ang inquest is summary, okay. What else? So, yun na, pwede na. Let's proceed to bail. Bail, a matter of rights. So kung dakpon gani ka, constitutionally guaranteed kina siya, right of every person lawfully deprived of liberty, na pwede ka makapiyansa. However, okay, we will know more about the exceptions later. Ang bail is also a security given for the release of a person in custody of law, furnished by him or bondsman. Pwede siya ang magpiyansa, pwede po daw uban nga tao to guarantee his appearance before any court. It may be given in the form of corporate surety, property bond, cash deposit, or cognizance. So, bail as a matter of right, okay, pwede na siya before or after conviction, okay, by the metropolitan trial courts, okay, municipal trial courts, okay, municipal trial courts in cities, or municipal circuit trial courts, okay, kanang mga less than 6 years, okay, nga mga kaso. Before conviction by the RTC of an offense not punishable by death, reclusion perpetua, or life imprisonment. So, matter of right, pwede ka makabail. Basta, dili ang imuhang offense, dili siya punishable of death, reclusion perpetua, or life imprisonment. Ingon si Attorney James, master daw kayo mo ng death, reclusion perpetua, or life imprisonment. Ingon siya nga, master dyan kayo na sa ina nga i-discuss. Okay. Ang bail, a matter of discretion, pwede di ay nga ang court mag-decide, okay, kanang reclusion perpetua maniyahang ko niyahang kaso, okay? Imprison ay okay, reclusion in perpetua pero dili man da ay strong evidence of prosecution. So pwede na siya upon discretion of the court. Upon the conviction by RTC of an offense not punishable by death, reclusion perpetua, or life imprisonment, admission to bail is discretionary, okay? At the same time, kato na kung giang ganiha nga kung dili gani strong ang evidence nga gi-present sa prosecution, pwede po nga mag-grant ang court, okay? Pero depende na sa court. Si court na mag-decide para ana, okay? If the evidence of the prosecution is not strong. Okay, next, arraignment and plea. Mura ko gihangak, Attorney James. Uy, mura isa man ni kasem nga discussion nga everyday. Lahi ba mong topic unya karon kay mura gi-isa ra siya, mura giganahan agad si attorney po nag-discuss. Gwapo mo agad kayo. Gusto niya i-present iyang handsome face. Okay. Anyway, arraignment. So, arraignment. Unsa man yung arraignment? Muna siya ang time nga, okay, pangutanon ka sa korte kung guilty ba ka or dili. Okay, so corresponds to the constitutional right of the accused to be informed of the nature of accusation against him. It must be conducted within 10 days if detained, 30 days if not detained, from the moment the case is raffled in court. Basta na nagani ang kaso sa korte, magsugod na din ang arraignment. So 10 days kung detained siya, 30 days if not detained. accused must be personally present. Dili pwede imong SPA ha, dili pwede imong uya, dili pwede ang imong silingan. Ay ikaw mas adto sa court TV kay kanang mag-arraignment na daw mi, dili na siya pwede class. Dapat ikaw gid mismo makita gid imong handsome and beautiful face before the court. And the court will ask you, guilty or not guilty. Okay, dili bitaw. Kung tala sa court na kay ng abogado, okay, kung wala kay abogado, ang judge mangutana kung gusto pa kag abogado. So if ang accused, kung wala gid siya abogado, dili pwede ang pao sa iya ha. Moingon siya nga, yes judge, gusto ko abogado. So ang court mag-appoint og counsel de officio para sa imuha. Arraignment again, during arraignment, mutanon ka kung guilty ba ka or dili guilty. A formal statement by or on behalf of the accused stating guilt or innocence in response to a charge. So gipasanginan ka ni Talpulano o ka nang nangawat daw kag manok. Guilty ka or dili? Okay, so mayon ka, guilty or dili guilty. So if the accused refused to enter any plea, dili ka magstorya. Okay, dili na siya guilty. Ha, dili ibuta kung magilom-ilom ra ka dato ini, guilty na siya. Okay, silence means yes, yeah, nangapay nga nga di ba nga statement. Okay, so but if the accused refused to enter any plea, okay, the court will charge enter, okay, not guilty for you. Or you make a conditional plea. Kanang wala ko nangawat pero or nangawat ko pero okay na mga conditional plea, okay, not guilty ang i-charge sa imo or i-enter sa imo. So dapat klaro gyud, guilty or not guilty. So kung guilty ka, wala na para end na sa kaso. Joke lang. End na. Tagaan na kay judgment, okay? Pero kung mayon ka dili guilty, din ha magpadayon ang kaso. So we can also have plea bargaining. Before arraignment, the accused may be asked if gusto ba siya mag-enter into plea bargaining. So may plea bargaining. Okay, muna siya ang process kung asa si accused o si prosecution, okay, dapat nagit si private complainant aniha, mag-decide mo nga i-settle na lang ang kaso. Okay, mutually satisfactory disposition of the case subject to court approval. So the presence of the offended party is required for plea bargaining and determination of civil liability. So kung di mo sagot si complainant, patay mahimuan na. Padayon yun ang kaso. Pero kung musugot si private complainant, well and good, okay, matapos na ang kaso. So, pre-trial, okay, so, kung not guilty imuhang giingon, then, usually, pag not guilty, so magpadayon na, mag-set na dayon si court of pre-trial. So, unsa man ni siyang pre-trial? Pre-trial is mandatory, it cannot be skipped. Unsa may discuss sa pre-trial o plea bargaining gihapon. So mangita gyapon nag-way si court nga kanang ma-settle ang mga kaso. Then stipulation of facts, okay, marking of evidences, okay, waiver of objections to admissibility of evidence, modification of order of trial if accused admits the charge but interpose a lawful defense, okay, or other matters that will promote a fair and expeditious trial of the civil and criminal aspect of the case. So, muna siya ang mga topics, okay? So, si plea bargaining, dili siya mawala ha sa bisag sa pre-trial. Gina-try yun sa court nga i-settle ang mga cases. After pre-trial, na mga cases nga usually gina-refer sa among office. So the court does not immediately proceed to trial if the crime charge is subject to mediation by the Philippine Mediation Center. So magkita-kita ta din sa among office. Yeah, naman nag-promote. And then, okay, kung dili gyapon ma-settle, dili gyapon ma-settle sa mediation, so mag-trial na gyud. Wala gitay mabuhat. After a plea of not guilty is entered, upon unsuccessful result sa Philippine Mediation Center, the accused shall have at least 15 days to prepare for trial. And the trial shall commence within 30 days from receipt of pre-trial orders. So continuous na siya class. Trial once commenced shall continue from day to day as far as practicable until terminated. And it may be postponed for a reasonable period of time for good causes only. The court must terminate the trial stage within 180 days from its commencement. Okay, but I would like to tell you in advance nga kung mag-law enforcement officers mo in the future, dili gini ang usahay sa kadagan sa kaso sa court, dili gid siya ma-realize ang 180 days. So let's give our courts, okay, the time for them to resolve the cases, okay, based on their capacity. So under the revised guidelines, I think na-discuss ni Attorney James sa inyo, ingon siya nga may do kayo mo sa mga examination processes. Okay, one witness must be presented in one day. Unsa may pasabot ana, the witness must undergo the entire examination process, okay, ng i-direct, cross, redirect, recross, if applicable, ha? So, diha tanan, tapuson ng witness, joke lang. Dinha mag-atubang ang witness sa iyahang kalbaryo nga nag-witness bitaw siya. Joke lang, class. So diha dapat tapuson gyud tanan. Pangutanon siya sa iyang lawyer, pangutanon siya sa pikas lawyer, kung napoy pangutana ang iyahang lawyer, napoy pangutana ang pikas lawyer, dapat tapuson gyud siya. We call that direct, cross, redirect, recross examination. So if you are the witness, you must prepare yourself and you must be honest with everything that you tell. Okay, the lawyer, the prosecutors, okay, kung kinsa man ka nga panig, kung kinsa man ka panig, okay? You have to be honest with everything you do para dili ka mataranta pag ikaw na ang tindog sa witness stand. And okay, so trial na ta. There are only 2 reasons for postponing a court hearing. First, ingon si Attorney Santonio kung kaslon daw ka, joke lang. Dili, force majeure. Force majeure ka ng mga calamity, mga floods, mga earthquakes. Dili nato na siya dili nato na siya mapunggan, okay? So kung mahitabo na siya, okay, postpone gid ang court hearing. Or physical inability of the witness to appear and testify. So what if ang ilahang balay layo, gid kay remote jud kaayo, okay? Or nabaka sa hospital si witness. So however, schedule of trial dates agreed upon during pre-trial, dili na siya pwede ma-adjust because of postponement. So muna nakalisod no, dili gid siya gina-encourage ang postponement. Dapat padayon gid ang kaso. Kaya decide man gid. Pero dili man nato siya mapunggan nga nga mga instances force majeure or physical inability of the witness to appear and testify. So ginatagaan po siya for humanitarian purposes. Gina-allow po siya sa court na yung mga postponements. Pero for good causes only, ha. Dili itong mga kay nakainom lang si lawyer or nakainom si witness the day before the trial. So last na gid ni Attorney James. Mura na jud ko binahubag-hubagan naman tingali ni ako akong tutunlan. Judgment and post-judgment remedies. So judgment, mo na siya. So si daghan na tanang witnesses, una day class ang mag-present ang witness ni prosecution. Then next ang witness ni defense. Okay? So kung tapos na tanan, kita na ni judge unsa okay, ang dagan sa storya, okay, nakita niya kung guilty ba gyud or dili guilty si accused based on the evidences presented. So there will be judgment. It is the adjudication by the court that the accused is guilty or not guilty of the offense charged and the imposition on him or her of the proper penalty and civil liability. So unsa may requirements, requisites sa judgment? Okay, it must be written in the official language, okay? It must be personally and directly prepared by the judge. It must be signed by the judge. So kung ang judgment wala yung signature ni judge, yes, void na siya nga judgment, okay? So pwede nga, may yung accused, void man dili ko guilty, kaya wala na sign ni judge, okay? So pwede gid kaayo. And then contains clearly and distinctly a statement of facts and the law upon which judgment is based. Okay, so muna siya. Pero dili lang sa tamasad, kung mapildi or mudawag ta sa kaso. Kung mapildi, okay, dili lang po na siya end of the world. Kaya pwede man ang post-judgment remedies. Actually, tuluran ni siya, pero daghan po actually. Ikapoy namang gagajak. So we have, tulo lang ha, new trial, motion for reconsideration and appeal. So sa new trial, inyong grounds lang gid ani is errors of law or irregularities. And then the second one is newly discovered evidence kana mga bago. Nga kung nakita unta nimo lahi unta ang result sa judgment, okay? Sa korte. And then motion for reconsideration, the ground is errors of law or fact, dili na ni siya require of further proceedings. And lastly, sa appeal, it will throw the whole case open for review and it becomes the duty of the appellate court to ipasaka siya kay another court ang mag-hear, okay, sa kaso in the appeal judgment whether or not it is made the subject of assignment of error. So appeal must be made within 15 days from the promulgation of judgment or from notice of final order appeal. If the accused filed a motion for reconsideration una before siya nag-appeal, okay, and was denied, the accused has a fresh period of 15 days to perfect an appeal. I think gimension na ni Attorney James sa inyong class ang NAPIS rule. So, kabalo ko nga, kabalo na mga. So, thank you so much for listening. I think that's all for criminal procedure and court testimony. Thank you, Attorney James, for the chance to speak before your class. And I hope they learned something. Bisag kadali lang kaayo no, hangak kaayo nga discussion because I think we don't have enough time. So thank you and See you sa court, mga future law enforcement officers.
Wow, amazing discussion. Indeed, a superwoman in the Supreme Court. So guys, we are very much grateful and thankful, no? Especially to our speakers, no? Grabe ka tumbling gyud kay tinuod man gyud no nga kini nga mga subjects tanan are law subjects ni siya sa criminology. And kung imo ni supay-supayon, it will run for 2 to 3 years, no? Nga studian. But with the superpowers of our lawyers and of course, no, our officers of the court, ato jud siyang na explain in less than 4 hours, no? So it's indeed amazing. Thank you so much, no, kay Attorney Boho, Attorney Diana, Attorney Gascon, Attorney Santo Niño, and of course our very sexy and pretty officer of the court under the Philippine Mediation Center, Attorney Lurico. So thank you so much. Grateful kayo ko, no, kayo you really responded to my invitation to talk to my students, because we need to recognize also the fact na dili gid ko perfect as a teacher. That is why I really need people who are experts to empower and of course motivate my students for them to come up with new, fresh ideas and perspectives in studying our law. Because as law enforcers, these are the necessary competencies that they need to really acquire. So with that, I would like to say thank you very much. And of course, now since Pasko na, Merry Christmas and advance Happy New Year. And you may now take a short while rest before you comply to the reflection, because they will be doing reflection papers on this in order for me to check whether they really appreciated and learned something from this event. So once again, thank you very much. God bless. And that will be all. Praise the Lord. Goodbye, everyone.